Great, very good. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this morning's sitting of the Massachusetts Appeals Court. The panel for this case is Justice Milkey and Justice Sullivan, and my name is Gabrielle Wolohojian. Just as in normal court, although we are conducting this argument by Zoom, each side will have 15 minutes to argue and there is no rebuttal. With that, I'm going to call the case, Commonwealth versus Xavier WYATT, 2019 P1212. We're ready whenever.
Hold on, I apologize for a second. My minutes have disappeared for some reason. All right.
Do we need to start over?
I just put it on pause. I hit pause. I can add it immediately. I apologize.
That's okay. Sorry, Mr. Rosenberg. It's like being a horse in the gate when there's a false start.
Oh, no, good. It's no problem at all. This is all, I appreciate the tech, and certainly had my own difficulties during all of this with the tech stuff.
I apologize. We're all set.
Thank you
Do
very
we
much.
need to, do we need to start all over?
No, I just hit pause recording,
Okay,
and now we're recording again.
great. So I'm going to just call the case again. Commonwealth versus Xavier WYATT, 2019 P1212. Attorney Rosenberg, we're ready whenever you are.
Thank you very much, justices of the panel and clerk. May it please the court. My name is Sam Rosenberg, and I'm representing Xavier WYATT, and we're asking that this court vacate Mr. WYATT's conviction because, in a case where credibility was central, a series of errors below, each independently and in their cumulative effect, deprived Mr. WYATT of a fair trial. I'd like to start, Your Honor, by discussing the issue of the medical records. During the day of trial, defense counsel and the prosecutor met to agree on certain redactions to the medical records, and the record indicates they came to some agreement. The problem is, whatever instrument they used to complete those redactions, it appears some sort of marker, failed to conceal the text below. Thus, jurors were given access to a treasure trove of prejudicial information, including two conclusory statements, one saying that the alleged victim had been in a domestic assault, the other in a fight. And the third, a statement that mother reports this has happened before and wants police or social work involvement, which would allow jurors to make the forbidden propensity inference and say, well, maybe we're not sure this happened here, but it's clearly happened before. We need to do something.
Attorney Rosenberg, we don't have an affidavit from trial counsel. Is that correct?
Yes, Your Honor.
And without that, how are we going to know that that at the moment when he signed off on the redactions, they were not adequate?
Your Honor, this case fits in that narrow exception to Zinzo.
No, that's not my question. My question is, how is it without an affidavit that we are to know that when the trial counsel looked at the exhibits, the redactions were not adequate? In other words, how do we know that whatever you're seeing now, because I assume you've looked at these exhibits before filing your brief, right? But how long was that after trial?
I first looked at the exhibits about, I guess, 5 months after trial.
Okay, so how is it that we know that the ink had not bled through more or something, and that at the moment of trial, when trial counsel signed off on them, they looked exactly the way you saw them 5 months later. How do we know without an affidavit from him that when he signed off on them, they were not those redactions were not adequate?
I understand the question, Your Honor. I guess we could never truly know for sure, but I think if you look at the record and counsel and the prosecutor agreed and the judge asked if they were okay, I think it's reasonable to infer that this is the same way they've looked. And I looked at them in August, I looked at them in November, and there was no difference. So I suppose it's possible.
But then why would counsel sign off on that if they look the way they did to you? And again, don't we need an affidavit to know?
I would say no, Your Honor, because I think this would just fit in that inadvertence bucket where I appreciate that things are moving fast, there's multiple exhibits, and I think it's more likely that trial counsel just didn't realize rather than saw them and thought they were okay, and then the ink sort of dried or something like that.
Well, to me, it looks as though there were two types of redactions. There were types that were made either by a computer or by some mechanical method, maybe a tape. They have very sharp edges. And then there are some that are made with maybe perhaps a black marker. Did you notice that?
I did, Your Honor.
Do you have any insight as to when some were made, why they were made in two different fashions?
It seemed from the record that some were made before and they each had a copy of the medical records and they sort of came to an agreement on the parts that they disagreed on. So I think that's why. And I think, Your Honor, the ones that seemed like they were made before, like you mentioned, those are the ones that remained redacted because that's how you'd want to do a redaction. You'd want to photocopy it after, you'd want to do it on the computer. A marker doesn't work as a redaction tool. Whether the ink is wet or whether it's dry, I'm not sure that would make a difference. And if they redacted these exhibits during lunch, during the trial, and then they came back, they heard more testimony, they went to closing argument, the ink would have dried or it would have smudged on the back of all the pages.
Okay, so, all of these interesting hypothetical factual scenarios or possible factual scenarios, aren't they just the type of thing we need an affidavit about?
Your Honor, I think in this case, no, because I think in this case that this is all in the realm of possibility, but I don't think it's in the realm of reasonable possibility that they were redacted and the ink took an exceptionally long time to dry and thus revealed the information a long time afterwards. We presume that jurors look at all of the exhibits, and I think we could also presume that if the ink were still wet, there would have been all sorts of weird problems. And when I looked at the exhibits, there's no smudging or anything like that. And these, as you've seen from the exhibits, this is several pages on top of each other. So I appreciate that it's a possibility, Your Honor, but I think it would be in the realm of remote possibility that the ink lost its redactive effect over time.
I have the exhibit in front of me.
Okay.
And the mother's comment, I don't know, do you have the exhibit in front of you?
So I have a picture I took of the exhibit because I didn't think that a photocopy could do it justice. I took pictures with my phone when I went to the clerk's office, so I do have it.
Can you point to me where because I couldn't see the statement that you're complaining about, that the mother's report.
So, Your Honor, it's in the trial exhibit, I believe 6. Let me just pull it up, Your Honor. I apologize. It's in the trial exhibit 7. So the second set of medical records on the 5th page and like the top quarter of the page.
What's on the top? Can you tell me what's on the top of page 5? Because the pages are not numbered.
Sure, Your Honor. Sorry, 1 second. Let me just pull up another copy that is zoomed out. And I apologize for the delay with this sort of tech issue. So on the top of the page, Your Honor, it says her information, and then it has like her biographical information, and then it starts off with an initial paragraph. There's a header that says medicine, it says author type registered nurse, and then you have this statement. It's the first paragraph on the page. It says mother, the patient reports a domestic assault 3 to 4 days ago. That's sort of the first line. It's covered in marker. And then at the end of that same paragraph, you have the statement that the mother reports concern.
Okay, so if when I'm looking at this, I can't read it, is that the end of the story?
I would say, as you know, Your Honor, it's a de novo review of the documentary evidence. And I felt like I could read it, and I showed the picture on my phone, which I didn't think did it very much justice. To some other people asked their opinion, and they also said they could read it. But at the end of the day, it is a de novo review, Your Honor. But what I would say is it would only take one juror to be able to read it. And in Quavo, we presume jurors look at all of the exhibits. And if even one juror could read it, they could say, hey, look, this is bad. We need to convict this guy, even if we have this disagreement on the credibility or on the timeline. Your Honor, if I could discuss, if I could move on to the second issue, the writing on the photographs. A second issue beyond the medical records is writing that was admitted over trial counsel's objection next to photographs that the alleged victim took and that her brother took of her injuries. One piece of writing said that indicated that the first photo, they were written, as you can see, sort of on the side of the photo. And one said that the incident took place August 4th or 5th, and the other said that the photo was taken on August 7th. Now, not only is this inadmissible hearsay that was admitted absent a foundation, there was actually no testimony who made these writings. These writings are not just merely cumulative, like the Commonwealth argues, but these writings would serve to bolster the credibility of the alleged victim and to destroy the defense's theory of the case.
How do they bolster the credibility of the victim beyond what the photos show?
Because, Your Honor, the timeline was the dispute, right? The defense's theory was that the victim should not be believed because of the timeline.
Right,
So
the victim testified when the photos were taken, when and where the photos were taken. So what if you're saying that it bolsters her testimony, doesn't it need to do, she says these photos were taken, one was a selfie, the other was taken by my brother when I was in, I guess, the hospital. And then the photo comes in. How does a notation as to the time and place that the photo was taken add much?
Your Honor, I think there's two things it does. I think, first of all, the question posed to the jury was, did she look like this on August 4th or 5th? And Mr. Wyatt's father testified that she did not. So having this writing that stands for the truth that she did look like this is basically case closed, and that's the danger of an out-of-court statement.
Okay, but the photo, she did testify. You agree that the photo itself, forget the handwritten notation on the side of it, was admissible. At least you're not making any argument that it wasn't.
Yes, Your Honor.
Okay, so I think what we really need to examine is the quantum of difference that's made by the notation that duplicates her testimony as to when and where it was taken.
Your Honor, in that I point to the Estevez case from 1999. It's an SJC case I cite in my brief, where you had inadmissible hearsay come in that really just repeated what the alleged victim said in that case, and the SJC drew a distinction between merely cumulative and cumulative of the complainant's testimony, where it ends up bolstering her credibility. You also have the issue of, because there's a lack of foundation, we just don't know who actually made those notations. It may be most reasonable to assume that the alleged victim did, but maybe someone in the DA's office did just to mark them because they weren't planning on admitting them. Maybe somebody did later. She may have written it a week later. We just don't know. But if you're the jury and you're looking at it and you say, okay, this is what she looked like August 4th or 5th, well, then I don't believe the father's testimony because he said she didn't look like this. And that, I think that's the danger, is just really bolstering that credibility, even if it is.
Did the defense counsel during closing argument, and I may have this wrong, go through the timeline and attach those photos to the timeline that was given on them?
I'm not sure I recall exactly. Trial counsel during closing made an argument that the alleged victim shouldn't be believed because she delayed going to the police, and also presented Mr. Wyatt to say she was uninjured the day after the incident. I'm not sure trial counsel endorsed, unless I'm forgetting something, I don't think trial counsel in closing endorsed that photo was taken August 4th or 5th.
Well, I think on page 141 of the transcript. Oh no, sorry, that was the Commonwealth's closing, so just ignore.
Thank you, Your Honor. So again, Your Honor, just with that issue, just responding to the Commonwealth's point in their brief, it's not merely cumulative because like in Estevez, it bolsters the alleged victim's credibility. And that was really the question. Do I believe John Wyatt or the father, or do I believe the alleged victim? Moving last, Your Honor, to the improper closing issue, the prosecutor began her closing argument by telling the jurors they're not here. They're not there to decide why the alleged victim waited to go to the police. And while a prosecutor is entitled to respond to a defense's argument in closing, they're not entitled to misstate the law. And under King, delay is a relevant factor. And here a
relevant factor to what?
Credibility.
Credibility, right. So it's not that, right. So you would have no quarrel if the Commonwealth, if the prosecutor had said, you can consider delay in assessing the victim's credibility, but delay is not an element of the crime.
I think that would have been a better argument, Your Honor. And I think the problem with this argument, and coupled with the trial judge's instruction that yes, the arguments are not evidence, but they're intended to assist you in understanding the evidence, I think that's an especially dangerous pairing, right? Because if I'm the juror, I may believe, hey, okay, that's helpful. All this relevant stuff isn't relevant. I have to just focus on the aspects of the crime. And I think under Skesny, somewhat recent case also dealing with an improper closing, the court made clear you have to actually address the error for the closing to be curative. And here, the closing and the instruction in this case rather falls short because I think if anything, it's ambiguous and could greenlight the jurors to say, okay, delay is not really a factor. And again, in a case where credibility was central, and in cases where courts find substantial risk of a miscarriage of justice or cumulative effect, it's those credibility cases where these errors can tip the scale.
I think we have your argument. Let me see if there are any further questions. No, thank you very much.
Thank you very much, Your Honor.
Attorney McLean.
Thank you, Your Honor. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. This court should affirm the defendant's convictions for 3 reasons. First, trial counsel was not ineffective regarding the redactions of the victim's medical records. From our review of the originals and from the clerk's file, they're not translucent as claimed. Second, there was no prejudicial error in admitting the photographs with the handwritten notations, as they were merely cumulative of the victim's testimony as to when the photographs themselves were taken, which was part of the authentication of the photographs. And third, there was nothing improper in the prosecutor's closing argument in asking the jury to focus on the evidence instead of on a delay in reporting the crime itself. So, Your Honor, I'd like to start with the handwriting on the photos because I have a specific transcript notation for you about the defense attorney's closing argument. Your Honor, on transcript page 138, the defense attorney did in fact embrace both the date and time of the 2 occasions on which she went to obtain treatment. That's at lines 8 to 9 and then at line 13. So he did in fact embrace that aspect of when those photographs were taken during his argument. So regarding
that portion of the argument doesn't specifically attach the photos to those dates. It does adopt the timeline of hospital visits.
Sure, Your Honor. Sure, Your Honor. Absolutely. So as to the other aspects, then I would point you to the medical records themselves that indicate the injuries that she suffered that sort of corroborate the existence of those photographs, and then her specific testimony as to when the photographs were taken. So really the handwritten notations were exactly what she testified to. They're merely cumulative, so they don't really offer anything substantive or different. They don't bolster or corroborate her testimony in any way. And I'd point you to the Shan case, where there's no prejudice, where the jury had the full picture from the witness themselves.
Counsel, why isn't one person's cumulative, another person's corroborative?
Well, Your Honor, if a second person is repeating what the first person said, then it would be corroborating that witness's testimony. But here, the problem is that it's exactly what the victim testified to, and she testified to specifically regarding the first photograph that she took it herself and the when and where it occurred. So all that information was already in front of the jury. This didn't really add anything to the case at all. Second point about the photograph.
It doesn't if one assumes that the credibility question is resolved in favor of the woman. If one views the credibility question as open, then it adds a lot, doesn't it? If the argument is she made it up, those photos are 3 years old, and I'm not saying that was the argument, but let's just take the hypothetical. A photo with a date on it would matter, right?
Well, not necessarily, Your Honor, because she provided the photo herself. She
Right.
took a selfie style photograph and then provided it to the prosecution that ultimately used it. So either she or someone in the prosecution office was the source of the information written on the photograph.
Right.
So there's no additional. Go ahead, Your Honor.
But the theory of the defense is that she gave an inaccurate date and time as to when those injuries were occurred. That has to be their theory, because they're putting forth the dad to say she didn't have those injuries on that day.
Well, Your Honor, even if you were going to accept that there was error in admitting them, then we turn to the prejudice prong. And the first thing to look at is that the jury acquitted the defendant of the top count of the strangulation account. So clearly it didn't influence them particularly much, if at all, in this case. And also, if we think about the standard of review that we're applying here, granted the defense did object to the initial admission of these documents. However, when the judge accepted them, and you can see that on transcript page 73, when the judge indicated he or she, I can't recall who the trial judge was going to admit them, they indicated they may redact them or may not redact them. Then when you go to the point when they're going through the exhibits to submit them to the jury, the defense, what's the word we used, was indicated they were satisfied with the exhibits as they stood. So really, to the extent there was an objection, yes, so you could review it for prejudicial error, but really that objection was waived when the defense agreed, yes, we're fine with these exhibits as they exist. And then you could look at their closing argument where they didn't really contest that. I mean, they acknowledged that she went to the hospital on those 2 days, and the medical records were in evidence, which documented the injuries she suffered, which were just corroborative again of the photographs themselves. And finally, the jury clearly didn't buy everything because they acquitted him of the top count, so it didn't have that much influence on them at all. So really what we're looking at here is a waived error because they acknowledged that they were satisfied with the exhibits that went back to the jury. So it would be reviewed for that substantial risk standard, or it could have been raised as an ineffective assistance claim, but wasn't. So turning from there to briefly address the closing argument. So there was no objection, so this is reviewed for a substantial risk. And what the prosecutor was doing here was responding to what the defense case, both in the cross-examination of the victim, and you could see that on transcript 83 to 84 and 87, where the defense attacked the victim repeatedly for the delay in seeking medical attention or seeking assistance from her family or contacting the police or going to the hospital. A series of questions about that on cross. That same approach was reiterated in the closing argument, and you could see that at 138, where they again attacked her credibility for not immediately reporting the crime or not immediately seeking medical attention or immediately calling her family for help, essentially arguing that it must not have been that serious if you didn't immediately reach out for assistance. So what the prosecutor did here was just a fair response to that attack on the victim's credibility. And all that the prosecutor did here was try to refocus the jury on evaluating the evidence of the incident itself, which is an entirely appropriate response. It's permissible to comment on a defense tactic, and it's permissible to request the jury focus on the evidence of the incident itself. And I'd point you to Andre and Jackson for that. And even if there was any error in here, the judge instructed this jury 4 separate times that the arguments of counsel are not evidence. Twice at the beginning of the case, then before the closing arguments were given, and then after the closing arguments were given. The jury is presumed to have followed that instruction. So we have no substantial risk of a miscarriage of justice here from the closing argument. So turning to the defense's first claim, the ineffective assistance claim regarding the redactions on the medical records. From my review of what seems to be their principal contention, which is Exhibit 7 at page 5. Justice Wolohojian, as you were indicating, they look to me like they were done with a computer. If those were done with redaction,
Not all of them.
yes, Your Honor, but the principal complaints that we're talking about are 2 pages. So on page Exhibit 7 at page 5, the page that you were specifically going through with Attorney Rosenberg, those look to me, I'm looking at them right here, granted an electronic version, but they look to me like they were done, the redactions were done with a computer.
Well, no, I think that's the confusion between page 5 and page 6. I think what he's calling page 5 is the page that at the top of the page, it might be the preceding page to what you're looking at. That the preceding page is just at the top, it says ED notes, ED triage notes by Jessica L. Jacinto, RN, at 8/7/2018, 9:22 p.m. Do you see that page?
Yes, Your Honor, that's the page that I'm looking at. And so the bottom of the first paragraph of text is the sentence that seems to be the
I don't know,
sentence of contention.
I can't really read that, but that looks like a handwritten. On mine, that looks like a freehand marker.
I don't know what to tell you, Your Honor. I had the exhibits pulled from the clerk's file, and what they indicated to us were the exhibits that were introduced into evidence looked to me like they were done with a computer. But even if they weren't done with a computer, we do not in any way concede that they were translucent at the time, Your Honor. And here, as you pointed out, we're dealing with an ineffective assistance claim that's made on the basis of the record alone, without the assistance of either an affidavit from counsel or an evidentiary hearing below. So it's in its weakest form possible. And I could put forward a reason off the top of my head, a tactical reason why you might be willing to accept redactions as they exist, because you simply want to get the exhibits back to the jury as quick as possible while your closing argument is still fresh in their head, if you think that's going to be particularly powerful. So there's a tactical reason right there. So then the question would just be, was that tactical reason manifestly unreasonable? And I don't think that's manifestly unreasonable. That seems like a rational choice at the time.
If I may, counsel,
Of course, Your Honor.
in the world of manifestly unreasonable, how is it that allowing something in that says this has happened multiple times now would not be manifestly unreasonable when made in a case of this nature, where one of the items in dispute is whether it happened at all? Do you have a case that would help us on that?
No, Your Honor, just the standard itself and the test for what is manifestly unreasonable. Something is only manifestly unreasonable if it's not rational based on what was known to the party at the time. So what was known to the party at the time was that he had just concluded, he or she, I believe actually the trial counsel was a woman, she had just concluded her closing argument that she may have felt was particularly compelling. The jury was back in the deliberation room waiting on the exhibits. So she wanted to get the exhibits into their hands so they could conduct their deliberations and come back with a not guilty verdict. However, Your Honor, I'd again point you back to the quality of the redactions themselves at the time. And I think Attorney Rosenberg slightly misconstrues the transcript here. And I'd ask you to look specifically at page 157 and what the judge said at the time when they were discussing this. The judge wasn't indicating that they were translucent. The judge was asking a question. Specifically, the judge's words were, and if you turn it to the other side, you can't see it if you hold it up to the light. Is that correct? Then the record indicates there was some conferring back and forth. And then at that time, after the conferring occurred, trial counsel indicated that he or she was satisfied with the status of the exhibits. So there was opportunity to continue working on the redactions if trial counsel felt that was an appropriate tactical choice. Trial counsel reviewed them and decided, I want to get these exhibits back to the jury. As Justice Wolohojian pointed out, we don't know what the exhibits looked like, exactly what they look like when this trial occurred. And we don't have the benefit of a motion for a new trial and an evidentiary hearing where that could have been fully fleshed out. So you have to make.
But I mean, why should we assume they changed? Let's assume, why can't we assume, and I have the original trial exhibit here in front of me, why can't we assume this is what the exhibit looked like when it went to the jury? And if I can read through the redaction, isn't that enough?
Respectfully, no, Your Honor, because you have to make the decision based on the record as it is before you. So you have the exhibit, you can review the exhibit yourself. But if you're going to evaluate it that way, then you have to decide whether or not this was a tactical decision or not. And the record doesn't indicate to you one way or another whether this was a tactical decision. And where the record is inadequate to analyze whether it was a tactical decision, an ineffective assistance claim should be rejected. That's McCormick. So here, I think I've put forward a possibility of why it could have been a tactical decision. The defense attorney believed that she had a strong case, had made a strong closing argument, and the jury was likely to come back quickly with a not guilty verdict. But that can't happen until she gets the exhibits in their hands. So rather than taking additional time to make additional efforts to redact the documents further, she wanted to get them back quickly into their hands. That could have been a tactical decision. And as we don't have a record about whether it was a tactical decision or just an error, then you have to reject the ineffective assistance claim. So then about the content of the other specific redactions that were in there, other than the mother's comment about it having happened multiple times, the substance of them were just that there was a violent altercation and when it occurred. And under McGann and under Cole, both that there was a violent altercation and when it occurred, those are within the hearsay exception for statements for the purpose of medical diagnosis and treatment. So the content of those statements would have been admissible anyway, even if you could see through the redactions. There's no consequence to them at all. So unless there are any further questions.
What about the third? Would that not have been improper?
The third, meaning the comment from the mother about the prior bad acts?
Yes.
Yes, Your Honor. Yes, Your Honor. That should not have come in. The Commonwealth does concede that. So as to the defense's final argument about cumulative error here, there are no errors to accumulate here. There was no ineffective assistance. The handwritten notations maybe shouldn't have, on the photographs, maybe shouldn't have come into evidence, but there was no prejudice suffered from that at all. So there's really nothing to accumulate here. As such, the Commonwealth asks this court to affirm the defendant's convictions, unless there are any further questions.
I don't see any. I think we understand your argument. Thank you both. Your arguments were very helpful to us. And
The case is now being recorded.
good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. Today I'm sitting with Justice Milkey and Justice Sullivan, and my name is Gabrielle Wolohojian, and will be your panel for this argument. Although we are conducting this argument in this form, all the ordinary rules of our courtroom continue to apply. Each side will get 15 minutes to argue, and there is no rebuttal. With that, I'm going to call the case. It is of Commonwealth versus Stephen Burns, case number 2020-P0135. We're ready whenever you are, Attorney Beck.
Good morning, members of the panel. May it please the court, Karen Beck on behalf of Stephen Burns. The overarching issue in this case is the quantity of inadmissible prejudicial information that was placed before the jury. This information overwhelmed properly admitted evidence of Mr. Burns' guilt and denied him a fair trial. I'd like to turn first to the information that the jury heard regarding erratic operation in this OUI case.
Counsel, before you go there, I just want to clarify. There are at least hints in your brief that while you focus on the hearsay and related confrontation clause issues, that you hint that there may be a larger problem here with the idea of having an officer testify as an expert with regard to forming an opinion based on what others said. To what extent are you making that argument?
So in raising that issue, Your Honor, was to, it was clear that the officers in the case were qualified as experts, or that was the prosecutor's intention. And the case law is that when an expert testifies on direct examination, they can testify about what their opinion is and whatever is within their personal knowledge, those two things. They can't testify that they relied on something else or refer to hearsay when they're forming their opinion.
What aspect of your argument depends, and I must admit I'm having a little bit of trouble hearing you, so I don't know if you can get closer to your microphone.
Okay.
What aspect of your argument depends on whether the police officers were experts or offering some kind of lay opinion?
My intention was solely to suggest that the trial judge in this case believed that because these officers had been qualified as experts, that they could go beyond what the testimony of a lay witness as to intoxication was. But on direct examination, that is simply not the case.
Well, there was no formal qualification of the witnesses, but there?
There was no formal qualification, but the prosecutor did take them through all of their experience during the trial.
Okay, but that happens with police officers every time they testify to any kind of fact. They put the police officer on the stand, they ask them about their training, their experience, and then they say, what did you see? But that doesn't mean that the police officer was an expert or testifying as an expert. But even if I guess what I'm trying to get at is, why does it make a difference to you whether the police officer is deemed an expert or not an expert? Wouldn't you have the same evidentiary concern or the same constitutional concerns either way?
Yes, in a word.
Okay,
yes.
so then why is the test different if they're an expert versus offering a lay opinion?
Not on direct examination, Your Honor.
Okay, so then why does it matter to us? Why do you make this, why is it important that you put this in your brief?
The only reason I raise it in the brief, and I don't want to make more of it than it is during the course of this argument, was simply to suggest that the trial judge in this case thought differently, and that as a result overruled a number of trial counsel's objections to what I think is clearly hearsay in this case.
All right, so if the officers testified as an expert, could the officers, without going into the substance of what they heard from the bolo, can an officer who's testifying in your view as an expert regarding intoxication, when asked what is it that you relied upon to form that opinion, and list their observations, say what I heard over the radio? Can they say what I heard over the radio?
No, they can't.
At all. They can't give you, they can't truthfully answer with a list of everything they relied on. Could they say they relied on treatises?
Not on direct examination. Well, in this case, that's not relevant. But you know,
is this hypothetically? Can they say they relied on secondary sources?
So Barbosa is clear, Your Honor, and it says
Sorry?
that Commonwealth versus Barbosa is clear. And what it says is that direct examination of an expert is limited to his opinion. Yes, I think he was intoxicated, or no, I don't. And matters within his personal knowledge. And saying, I heard another officer say that is not.
No, not the say that part. So why isn't it in his personal knowledge what it is that he relied on?
I mean, that opens the door to any.
Relied on my education. I relied on secondary materials I looked at. I relied on information I heard over a police report, over the police radio.
This is when someone says I relied on a treatise, that does not imply anything about what he read. When someone says I formed an opinion that someone was intoxicated based on what someone said on the be on the lookout, that's implicit hearsay. The jury can infer that what was heard on the be on the lookout was this guy's drunk, or this guy was driving like a madman. So,
Oh, but that's a different story. There's, I mean, if the person says I relied on a treatise, why isn't that relying on implicit hearsay? Everything in the treatise is hearsay. Because the jury
can't draw the conclusion from the assertion I relied on a treatise to what that information in the treatise is. If an officer says,
okay, so I think this is really the nub of your argument, which is that the jury was going to itself supply what was the information in the bolo, and that
Right.
was really the problem.
yes,
Okay, but so, and I think that's correct. I think that's actually the nub of your argument. But then why is it that since evidence came in as to what was in the bolo, that there's just no harm?
Your Honor, the problem in this case is, if you sort on one hand the admissible information, and on the other hand the inadmissible information that the jury heard, there's a substantial quantity of inadmissible information that they heard. And Commonwealth Kindle says that a testimony of a witness should not be pumped up by repetition. And the entire line of fresh complaint cases say the same thing. The more often the jury hears what someone said, the more weight they're going to give it. And that's why Commonwealth, I believe it's Commonwealth versus King, has first complaint now, because this repetition is in itself harmful. And in this case, the properly admitted evidence was not overwhelming. And yet the repetition of what Officer O'Donnell saw for seconds was mentioned by the officers repeatedly.
But why isn't there a separate problem with the officer testifying as an expert? Outside the police context, there's a lot of case law that says lay witnesses are not supposed to testify as experts and vice versa, that this is to be avoided.
I agree that it's to be avoided, and that the qualification of these officers as experts does lend more weight to their testimony when anyone can give an opinion. But Commonwealth versus Canty is clear that officers can be qualified as experts in the OUI context, and that's cited in my brief. And so that's the law on that matter, and I'm not contesting.
I mean, I know you keep saying they were qualified as experts, but there was no qualification, or else I'm going to ask you for the page reference in the record so that I can find it.
You're quite right, Your Honor. They were taken through their qualifications.
They were taken through their professional qualifications, and then they were asked whether they formed an opinion as to the defendant's intoxication.
Yes.
Counsel, before we get any further, I need to ask you how we're supposed to deal with the fact that part of the day 3 of the trial could not be recreated. I mean, normally we say, oh, well, it's not recreated and the defendant has the obligation to do that. But here, the parties appear to have agreed that, for example, the closing arguments could not be recreated. So therefore, we as an appellate court are deprived of seeing the extent to which the Commonwealth, for example, emphasized the erratic driving in its closing argument. What are we supposed to do with that?
I mean, I agree that that's the case, Your Honor. It's problematic. I think it's essential to deal with the record that we have before us. In the same way that if a sidebar can't be recreated, one has to make reasonable assumptions and deal with the record before one. One issue in the time remaining that I want to bring to the court's attention is in terms of testimony about erratic operation. Officer Cristiano testified about erratic operation described by other officers, plural. And I think a reasonable jury would conclude in these circumstances, obviously, that at least 2 and maybe more officers observed the defendant driving the motorcycle erratically. But that was not the case, and that was not the state of the evidence. And I think Commonwealth versus Parks, which is cited in the brief, makes it clear that this is a confrontation clause violation. In Parks, a tractor trailer driver testified at trial.
Counsel, we've read the briefs.
Okay.
On that point, and we understand what your argument is on that. Can we turn in the remaining time to the 3 unopened nips?
Yes, certainly.
And cutting to the chase, you seem to assume that, had your client been diagnosed as an alcoholic, that could not come in. Is that in fact true?
That is true, Your Honor. And I would cite the Commonwealth versus Shine is cited in my brief. The defendant's purported alcoholism is not relevant to the question of intoxication at the time of the crime. This is propensity evidence, pure and simple. And the question of whether someone is a drinker is not relevant to whether they were intoxicated at any particular time. Commonwealth versus Nagel, Commonwealth versus Mallet, all cited in the brief.
Why were the nips not relevant to the question of opportunity? The defense was that although the defendant had been intoxicated hours earlier, he had been at the police station most of the day and had sobered up. And there was no evidence that he had been drinking before he got on the motorcycle. That was the defense. So if we combine the fact that he leaves the police station with no nips in his pocket, but he's found with nips in his pocket when he's on the motorcycle, why isn't that relevant to undermining that defense?
Your Honor, if it were reasonable for the jury to think that Mr. Burns had not had the opportunity to access alcohol prior to his driving away, then it would be relevant. And the relevance might be more important than a prejudicial effect. But here, he goes home. He goes into his son's room. They're all drinking. It's clear that this is a household where people drink. He says to his son, "Where's the beer?" So I think the jury is not going to be pondering, where did he have the opportunity to get alcohol? The nips are—
That was his defense. That was the defense that the defendant asked the jury to adopt.
The prosecutor asserts that in their brief, but I don't think that's true. I think that—
How are we going to know that without seeing the closing argument?
We can't know for sure what the closing argument was without seeing the closing argument, obviously, Your Honor. But I think that the question of whether the defendant had the jury would have thought the defendant had an opportunity to drink absent the introduction of those nips makes no sense.
Let me see if there are any other questions. No? Okay, seeing none. Thank you very much.
Thank you.
Attorney Elliott.
Thank you, Your Honor. May it please the court. Krista Elliott, Assistant District Attorney for Middlesex on behalf of the Commonwealth. I would first like to briefly touch on the purported qualification of the two arresting officers as experts. Here, they simply were not qualified as experts, as this court has pointed out. The brief testimony from each of those officers as to their training and experience was not to particularly technical training. It was more to observations that the court has consistently found.
Counsel, the reason lay people can testify that someone looked drunk is on the theory that we've all seen drunk people, we know what it looks like. Here, the officers were forming their opinion not based simply on their personal observations, but on what they heard from other people. How is that lay testimony?
Well, I think that's a different issue than lay testimony versus expert testimony in this case. I think that goes into the hearsay arguments that defense counsel makes. And here, the majority of the complaint of testimony was not in fact hearsay, but to the extent that it was nearly cumulative of other properly admitted testimony. Further, even if all of the complaint of testimony were stricken in this case, the Commonwealth's case would still have been more than strong enough to convict the defendant of operating under the influence of alcohol.
But that's not the issue, is it? This is not a sufficiency issue. It's your sister more or less concedes that there's sufficient evidence. The issue was he prejudiced by the introduction of implicit hearsay and the related confrontation clause issue?
And Your Honor, I would argue that no, he was not prejudiced by that. Specifically turning to the statement from Officer Fitzpatrick regarding that he had formed his opinion in part of the defendant's intoxication based on the statements of the bolo. The contents of that bolo were already before the jury, both through Officer Cristiano's testimony and also from the defendant's son's testimony, in which he specifically testified that after the defendant left on a motorcycle, he called 911 and, quote, "I told the police department my father's drunk and he left the house on a yellow motorcycle," and that appears at Record Appendix 23. So the jury would not have been, there would not have been any conjecture as to what was within that bolo. The jury was well aware at the close of the Commonwealth's case that
Well, what about the reference to the other officers, plural, witnessing erratic driving?
Certainly, Your Honor. So in this case, the confrontation clause is not implicated. Commonwealth v. Parks, that the defendant references the defense counsel references in her brief, is very specific to that context in which there was a very weak case, or a fairly weak case, where one witness was a truck driver, testified that a defendant had exposed himself. And then the Commonwealth presented two additional police officer witnesses who specifically testified that there were multiple calls that came from other tractor trailer operators. And as such, the court essentially found that that testimony was put before the jury for the purpose of insinuating that there were more callers than there was actually evidence that there were. Here, this erroneous plural officers is, I think, only that. I think it is erroneous. Throughout the rest of the testimony from Officer Fitzpatrick, there is no indication that there were other officers who had put any information out over the radio outside of Officer O'Donnell, who did testify. And Officer O'Donnell's testimony does not give any indication that there were other officers who had observed the defendant's erratic.
Okay, but let's focus on Officer O'Donnell's testimony for the moment. She sees the motorcycle do a wide right onto Maple Street. She runs over there. She sees the guy perpendicular to the road, backing up the motorcycle, which I don't know if you've ever ridden a motorcycle, but this is not an easy endeavor. It's going back and forth. And then he drives away a half block or so to the end of Maple Street. As he's going from a stop, she testifies, swerving as he's getting the 500-pound bike going. It's not super strong evidence of erratic driving, is it?
Certainly not, Your Honor. And the Officer Cristiano did in fact testify on cross-examination that you would have had to put your feet down in order to back up a motorcycle. And so the defense was able to in fact bring that out. I would also note that erratic operation is simply not a prerequisite for proof of operating under the influence. It is just one of the many factors. And here, there were many observations from officers Fitzpatrick and Cristiano and the booking officers that indicated that the defendant was intoxicated at the time. He consistently swayed back and forth. He smelled of alcohol. The scent of alcohol, of an alcoholic beverage, became stronger as officers got closer to him. He struggled to respond to commands appropriately. He became combative during booking. He had to hold on to a desk in order to stay upright, and he wove back and forth and was unable to keep his balance as he walked across the room during booking. So the erratic operation was not necessary, certainly for the Commonwealth's OUI case here.
To the extent there's a confrontation clause issue preserved, don't we have to find that any error was harmless beyond a reasonable doubt?
Certainly, if that confrontation clause error was preserved, that is what this court would have to find. But the Commonwealth's argument is that there simply is not a confrontation clause error. And again, given the overall state of the evidence and the minimal testimony at issue in this particular instance, I think that this court certainly can find that here. If there are no further questions as to the hearsay argument, I would like to move on to the issue regarding the 3 nips that were introduced into evidence. And certainly the trial judge in this case properly allowed those 3 nips of raspberry Smirnoff vodka to be introduced into evidence because they were relevant to show the defendant's alcohol use. Here, this court reviews the admission of that evidence for an abuse of discretion. And on the record, the trial judge specifically noted that she was allowing this evidence because the defendant presumably did not have the nips on his person during his first arrest because they were not listed on the booking sheet, and that the evidence at the time of his first arrest showed that the defendant had between $83 and $84 on his person.
So why doesn't that show that he's about to drink because he's got 4 unopened bottles, not that he has drunk?
And it could certainly be evidence of that. The fact that the evidence, this is somewhat weak evidence, certainly, and the defendant did capitalize on that, in fact, at trial. He specifically through his questioning, his attorney, through questioning and cross-examination of the officer who was the one who found the nips on the defendant's person, specifically brought out that these were sealed nips, that the officer did not find any open nips on his person, that the nips were very clearly full. And so the fact that the evidence that only goes toward the fact that the evidence is not particularly prejudicial to the defendant at all. In fact, he was able to leverage it for his benefit.
Why wouldn't the image of a nip evoke in the mind of an ordinary juror that someone's an alcoholic?
I don't.
If you're not a teenager, who drinks nips?
I don't think that there's any indication that that would necessarily raise an inference that someone is an alcoholic. It certainly raises an inference that someone perhaps does drink, but that is the same inference that you would have regardless of what type of alcohol you would have on your person. And not only that, but in this case, the entire defense was essentially conceding that the defendant had been very intoxicated earlier in the day and conceding the charges for threats and disorderly conduct. And so certainly it was not an issue at trial whether or not the defendant is a drinker. And as such, this certainly was not impermissible propensity evidence. And I would note that, consistently, this court has held that nips are a sign of alcohol use, that they are the court has found them to be admissible. I would specifically draw the panel's attention to Commonwealth v. Ritchie. It's 97 Mass Appellate Courts at 1102 at page 2. It is an unpublished opinion, but in that opinion, the panel found, quote, the defendant's possession of a nip bottle of vodka, which may be used for quick and surreptitious alcohol consumption, may be understood as a sign of alcohol use. And here we are looking at alcohol use in the context of whether or not the defendant was intoxicated at this point.
Do you have any published case that says an unopened nip is relevant?
I do not have one that specifically says that it is relevant, but in Commonwealth v. Faherty, 93 Mass Appellate Court, at 129 at 130, a 2018 case was an OUI trial at which an officer testified he found 4 unopened bottles of bourbon in a saddlebag of a defendant's motorcycle. And so that's not an unopened bottle of nip, but it is a discussion of an unopened bottle of bourbon.
Well, I looked at Faherty, but I noticed that was in the fact pattern. Did I miss an analysis of that?
No, Your Honor, it does not appear within the analysis. It's just, I cite it as to show essentially that, the unopened bottles of nips do in fact, or unopened bottles of alcohol do in fact appear with somewhat regularity within fact patterns. I would also note that within Ritchie, again, recognizing it is an unpublished opinion, that case also does note that when the evidence shows that a nip bottle was unopened, the prejudice to the defendant is significantly mitigated. As to the distinction between published and unpublished cases in this context, the reality is that when I was doing the case law research, the vast majority of the cases that do deal with this topic tend to be unpublished. And I did a bit more digging yesterday and was simply unable to find additional published opinions on that subject.
Well, it's one thing for a case to be unpublished. It's another for a case not to address the legal issue for which you are citing it.
Certainly, Your Honor, and I'm not suggesting that there was analysis in Flaherty about the closed bottle of alcohol. Certainly, I think that Commonwealth v. Ritchie is much more on point, is the most on point case that I can point this court to.
Do you agree with your sister that SHINE stands for the proposition that evidence that someone's an alcoholic does not come in?
Your Honor, I apologize. I would have to review Commonwealth v. SHINE. In this case, it's simply, this was not evidence that the defendant was an alcoholic. And so I think that regardless of SHINE's holding, that it's inapposite.
Well, apart from whatever SHINE says or doesn't say, do you think evidence that someone's an alcoholic could come in this context?
In this context, I do not believe that evidence would come in, but again, it is not what came in. What happened in this case? This was evidence that the defendant specifically had alcohol on. He had 3 nip bottles in his front pants pocket. The evidence came in for what it was worth for the Commonwealth, and at the end of the day, even if those nips had not been entered into evidence, it would not have mattered. And fundamentally, at the end of the day, the question is whether or not the trial judge abused her discretion in letting in those nip bottles. And this simply did not fall outside the range of reasonable alternatives for her to let those nip bottles into evidence in this case. We'll move on to the third issue if there are no additional questions from the panel. Here, the trial judge properly denied the defendant's motion for mistrial when Sergeant Zino testified generally about a person's right to refuse a breathalyzer test, because this was simply not impermissible refusal evidence. It certainly would have been better if that testimony did not come in, but here Sergeant Zino was the booking officer for the defendant's first arrest of the day, specifically the disorderly conduct and the threats charges. He testified that generally, if somebody were arrested for OUI, he would have give somebody the opportunity to take a breathalyzer test and that they could choose not to.
Counsel, I understand what you're arguing in terms of why this brief stray reference did not warrant a mistrial, but could you address your sister's point that it's hard to imagine how this was inadvertent, in the sense of, what question was the prosecutor seeking to elicit when she asked this?
And Your Honor, honestly, unfortunately, I don't know the answer to that question. I think that the prosecutor's state of mind is at that moment in time is difficult for us to necessarily know. But the question before the court is whether or not it was an abuse of discretion to deny the motion for mistrial. And here there was a forceful instruction to the jury that they were not to take into account the testimony they had heard. The answer was stricken. And the trial judge again gave a brief instruction at the close of evidence. She was very careful not to use the word breathalyzer, and through this forceful instruction was able to kind of mitigate any prejudice to the defendant could have occurred based on this erroneous testimony.
Last question, at least from me. What are we supposed to do with the missing part of the transcript? In circumstances where the parties are unable to recreate it, who bears the burden of that?
I believe that the burden is certainly on the defendant to produce a full record, but in this case, certainly the defendant and the prosecution worked together to try to reconstruct this record. And so in this case, I think that the best thing for this panel to do, it would certainly be to look at the arguments that were pretty consistent throughout the case. Here, it was very clear that the defendant, through his opening statement, was conceding both the threats and the disorderly conduct charges in order to counter the OUI charge later on. And that thread continued throughout all of the questioning. And so I think that looking to the opening, in addition to the threads of cross-examination, certainly shows where the defense argument was in the same way that it shows the Commonwealth's arguments.
Well, should we assume the Commonwealth made a big deal of the erratic driving testimony or not?
I don't think that we can assume that based on the record. I think that we're confined to the record in this.
But we can't assume the opposite either, correct?
I think that the court correct. I think that we can't make an assumption one way or the other and are confined to what did occur within the context of the questioning and the opening arguments. And seeing that my time has expired, if there are no further questions, I would rest on my brief.
I don't see any, so thank you both. It's an interesting case. We appreciate your excellent arguments.
The case is now being recorded.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting by Zoom, given the ongoing pandemic. This morning, your panel consists of Justice Milkey, Justice Sullivan, and me, Gabrielle Wolohojian. Although we are conducting argument in this format, all the ordinary rules argument in our ordinary courtroom apply, which means that each side gets 15 minutes to argue and there is no rebuttal. With that, I'm going to call the case of Commonwealth versus Kyle Palazzotti, case number 2019 P0581. Attorney Rotundo, we're ready whenever you are.
Thank you, Your Honors. Attorney David Rotundo for Mr. Palazzotti. The first issue in the case is the issue of duplicate convictions. The defendant was convicted of possession of a firearm and possession of a large capacity feeding device. Now, our argument here is that these two verdicts arise out of the possession of a single firearm. This was one gun recovered as a single entity, the magazine or the feeding device being in the gun when it was recovered. So we're not suggesting that one cannot be convicted of possession of a firearm and separately for possession of a large capacity feeding device. However, I would suggest that to have separate convictions, you need the scenario where a firearm is recovered separately from the feeding device. And as we all know, possession of a firearm, a conviction can stand whether it's either loaded or unloaded. Now, the Commonwealth in their
pick up on that. Since the statutory definition is loaded or unloaded, and the high capacity magazine, and I understand that you have an argument about the sufficiency of that, but for purposes of this discussion, let's just assume it was a high capacity magazine, can be, it is separate. My understanding is that under Vic, we don't look at the facts of the case, we simply look at the elements of the offense. And the high capacity magazine is a separate entity for purposes of the statute. So are we even allowed to look at whether or not the two were joined at the time they were recovered? Or must we simply look at the elements of the offense under Vic?
Well, I think the problem with that is that I mean, Mr. Palazzotti could have been indicted under 269 Section 10M for possession of a large capacity weapon. The firearm that would possess that type of clip would be considered a large capacity weapon. So he could have been indicted under that statute.
But he wasn't.
He wasn't. So, I mean, there's an inherent injustice right there. I mean, so one person can be indicted under 269M, get one conviction, while another, when we have the same scenario, can get indicted under two separate statutes.
Which I gather would have ramifications under, would it have ramifications under the ACCA for him to be indicted under two separate?
I would think, but I would think the predicate, you'd have more predicate offenses for.
And that may well be the case, but we have this thing called the Declaration of Rights that tells us as judges that we are not allowed to interfere in charging decisions. How do you address? I understand what your argument is, and I understand the policy concerns underlying your argument, but we have Vic that tells us we look at the elements, and we have Article 30 that tells us we have to stay in our lane, so to speak.
I would argue that under the two offenses are so closely related as to constitute a single crime. I would argue, I would make that argument.
But the legislature's made them two separate crimes. That's another exception to the duplicative conviction doctrine under double jeopardy.
But I think the reason for that is the policy behind that is when you find a weapon unloaded, and then you find a weapon, and then you find a magazine and separately from the weapon. Maybe if it's a home, if it's in someone's home, you find a magazine separated from a weapon. When you have the magazine inside the weapon, I would argue that you would have to be charged either under Section 10A or Section 10M, one or the other. You can't have it both ways.
What I hear you arguing is essentially two things. One is that under the facts, when the defendant possessed this item, the magazine was in the gun, and the only way they became separated was through state action when the police officer took the magazine out of the gun. And that state action shouldn't be the premise for charging the single object as two separate objects. That's one argument I sort of hear you saying that's based on the facts. And the second argument I hear you saying is that there's, in the civil context, we would call this claim splitting. That if you have a single claim, you can't really split it into two. And that's what I sort of hear you arguing as maybe a legal proposition of some sort.
Yes.
Am I correct on that?
Yes, I am, and you are. I'm sorry. That's an excellent argument. And you know, I took a look at the Ragland case that the Commonwealth cites in their brief, and it was a 128 decision. However, I think that case is unclear whether, and it's a 128, so maybe the facts weren't fully developed in the opinion, but it seems unclear as to whether the firearm was found separately from the clip. I mean, I know in that case we have two separate convictions for a firearm and large capacity feeding device. So when I read the decision, I cannot discern whether it was a single entity or two separate elements. So that's why I would say that that's not a persuasive case. Well, in this argument.
Is it your view that the magazine or a magazine that fits the particular firearm needs to be in the firearm in order to be operable?
Well, I would think an operable firearm
It's one capable of being discharged.
yes. I don't have the answer to that question. Whether an unloaded firearm would be considered operable, I would suggest that it would be if under the statute it says that possession of an unloaded firearm is a crime. So I think I think operable. If it didn't have ammunition, I think it would still be operable.
Oh, I mean, my understanding of guns is really minimal. So, but I'm not talking, the magazine could have bullets in it or not have bullets in it, right? It could be an unloaded magazine. But if the gun doesn't have the magazine itself in it, is the gun operable?
I would suggest that it is. I mean, just based on the fact that the statute would not. I mean, unless there's.
I would think if repairing a firing pin is enough to make a gun operable, that putting the magazine in. I don't think you'd be making a terrible concession, counsel. If I see you struggling with that, but I think given the case law. We're just trying to figure out whether or not you're making an operability argument or not.
I'm not making an operability argument at this point. I mean, it's just duplicate conviction type argument. If there's any more questions, I'd like to move on to the next issue. The next issue is really is a knowledge issue, whether there was enough proof that the defendant had knowledge that the feeding device was capable of holding more than 10 rounds. Now, again, we have the situation, the facts here that there was no testimony that the defendant knew the gun was loaded or that he had fired a weapon. And I looked to the two cases, the Cassidy case and the Resendi case. Really none of the factors that are outlined in the Cassidy case where the court inferred knowledge.
Counsel, are you familiar with the recent Supreme Judicial Court case of Silvello? I can give you a brief explanation if that would be helpful.
Sure.
I've looked at the pictures that are in the record, and Silvello, which came up from a divided opinion in this court and went to the SJC. In Silvello, the SJC said, if you can look at the gun and know that there's a bullet in it, that's enough to show that it's loaded. And the argument that's being made here is that if you look at the pictures and you can see that the number 17 would be visible at the bottom of the handle when the magazine is in, and there were 17 rounds in the weapon, that's enough. So I guess my question to you is, looking at those photographs, is there enough there to show us that it would be clear that there were 17 rounds and that the ammunition was visible in the 17th round?
Well, I would argue that because this clip was not separated from the gun, there was no visual in this case. And I would argue that the Resendi case would be the case that's on point.
Did both the gun, the exhibits went into the court, into the jury without the ammunition? Did both the firearm and the magazine go into the jury room?
Yes, I believe there was separate exhibits. However, the issue is whether the defendant had knowledge that it was a high capacity clip, and there's no evidence in the record that the defendant either testified that he fired the weapon, or he knew it was loaded, or he had some familiarity with the clip in the weapon. So, or that he had even separated the clip out of the weapon. We don't know.
But if the clip is large enough to stick out from the bottom of the weapon, and the ammunition is visible within the clip, would that be enough?
Yes, but we don't have that in this case.
Do we have it in the picture?
And I think the Commonwealth made that argument. We have two exhibits. We have the gun and we have the clip. And I believe they made an argument that you can draw the inference that the magazine extends beyond the base of the grip of the firearm. And I really don't know what that means, because in every firearm, and I have limited familiarity, but every firearm I've ever seen with the clip inserted, it's a clean insert. I mean, there's nothing sticking out. There's nothing that looks odd. So you can't tell. I mean, the base of the clip is a plastic piece that inserts into the gun and it mates up. I mean, there's no.
Do you have the photograph there with you?
Yes.
Can you just take a look and tell us how you can make that argument based on the photograph?
How I can make the argument that,
I mean, looking at the photograph, can we make these set of factual assumptions that you're making about the clip being flush with the base of the firearm?
yeah, I think you can. Because I think if you look at the base of the clip, there's a plastic piece. And if you look at the base of the hand grip on the firearm, there is a recess that the clip goes into, and the plastic piece is accepted within that recess, and it's flush. I mean, they make firearms to look pretty. I mean, you can't tell based on what clip is in there that there's 10 rounds or 17 rounds.
That doesn't mean that this particular firearm was sold as one containing a high capacity clip. But you've only got 58 seconds to go. So is there anything else you'd like to touch on?
No, I would ask the court to look at the Resendi case, and I think that those facts are on point with my case. Now the issue 3, and I think it's much of a closer issue, is whether he knew that the defendant knew the firearm contained ammunition. And I would point again to the Resendi case and the factors in the Resendi case, and distinguish our case where we don't have such we don't have those factors: familiarity with firearms, threatening evidence that the firearm has been fired, evidence that the ammo separately recovered from the defendant's person, and that type of argument. So it's a much tighter argument. Issue 4, again, I would submit on my brief for the final issue whether the whether the motion to suppress was properly denied.
Great. I see your time has expired. We understand your arguments, and we've got the brief. So we'll hear now from Attorney Presiding.
Thank you. May it please the court, ADA Raquel Presiding on behalf of the Commonwealth. I'll open by addressing there's sort of a dual argument with respect to knowledge that the defendant was raising, defense counsel, I should say, was raising towards the end of his argument. And I'll speak specifically with respect to the issue of knowledge as to the large capacity nature of the weapon or of the magazine in question first. Obviously, this case is factually very different from Cassidy, which is, of course, the case in which the court made a specific ruling regarding this knowledge requirement. But despite this case's dissimilarity from Cassidy, one thing that stands out about Cassidy is factually it's a very unusual case. It's a case in which the defendant took the stand at his own trial and testified extensively about his own familiarity with and use of firearms, which is unusual. So certainly it can't be that a case like Cassidy is the only kind of case in which the Commonwealth can adequately make out case with respect to the defendant's knowledge. Obviously, this is a case where the defendant did not take the stand. We don't have the kind of testimony that we did in Cassidy. But I submit that nonetheless, the case is differentiable from Resende, which is more factually similar in that we have a gun recovered on a street. And of course, that jury in Resende did not have the kind of extensive testimony from the defendant that they did in Cassidy. In Resende, though, the court made specific findings regarding this sort of visual nature of the magazine in question. It was a 15-round capacity magazine, so a smaller round by two, or a smaller magazine by 2 rounds than the one that we're talking about here. It had 14 rounds inside, so it was nearly loaded, but not fully loaded. The court specifically found that the size of the magazine in Resende would not have been apparent once inserted in the gun, and that it could not be characterized as obviously large, like the kind of large capacity magazines that were discussed in Cassidy. The court in Resende also specifically noted photographs and evidence that seemed to show that the magazine would not protrude from the grip, and that's differentiable from the facts here. While
how can we tell that? I'm looking at the photographs. I can't tell if it would extend beyond the grip or not.
Well, and the jury, to be clear, the jury did not see any photographs of the magazine inserted, nor was it ever inserted for the jury to see. I submitted, as the court noted during the defendant's argument, the jury did get both the magazine and the firearm itself together in evidence. It went back for the jury to view. So I submitted some photographs in my supplemental record appendix to sort of give the court an idea of what the jury would have been able to look at holding those 2 items in their hand.
Right, but I mean, again, I don't know that your argument is self-evident from those photographs. I don't know what happens to the magazine once it's in the grip of the firearm, but it wouldn't be beyond the realm of, I would find it entirely reasonable to think that the magazine needs to extend up into the barrel, for example.
And given the shape of the end of this particular magazine, it looks like it fits quite well into the handle of the gun.
First, I would note, reviewing of obviously the standard here is Lattimore, and the question is whether a jury could essentially have inferred the opposite of what Your Honors just proposed a jury could infer. And a jury could have inferred
no, reasonably inferred.
Fair enough.
And right now I'm looking at what could be characterized. I'm not saying it would be, but an absence of evidence as to whether or not this magazine fits flush or not. Because we don't know, unless you can tell us there was testimony, that this stops at the block portion of the gun or goes up into the barrel of the firearm.
There was no testimony regarding that. And I think, one thing that's worth noting here is obviously this case was tried before the court's ruling in Cassidy. And were this case being tried today, I'm sure an ADA would have asked different questions regarding the specific fit between the magazine and the handle of the gun, or the grip of the gun in question. That being
so, assume that we can't infer that the magazine extended below the base of the gun.
Well,
assume that.
Okay.
And I just measured it. The width of the barrel is 1 inch, and the distance below appears to be 1 inch. So assume that.
There are other factors here apart from the question of whether or not the base of the magazine would have been flush against the base of the grip. Again, as I think was also referenced during the defendant's argument, this also happens to be a magazine that's stamped with capacity numbers going from 5 to 17. The testimony that was offered at trial was that the magazine, when it was recovered, was fully loaded with 17 rounds, such that somebody looking at the magazine when it was fully loaded would have seen not only the number 17, but the hole just above the number 17 with a round visible through it. coupled that with the fact that the gun in this case was on the defendant's person, which, while not decisive, is a factor from which the court can and should infer that this is an item with which the defendant would presumably have been more familiar than an item in, say, the glove box of his car or even in a backpack that he was carrying. I think the court and I think the case law.
Counsel, are you familiar with Commonwealth versus Savello?
I am not familiar with that case.
All right, because what the SJC relied on in Silvello, and in that case, the fact pattern was a little different because the gun was found underneath the seat of a car in which the defendant was a passenger. But what the SJC relied on in that was the fact that you could look at the gun and see that it was loaded. Not when it was taken apart, not when it was being loaded, but that it was loaded. That if you picked it up to carry it away, you could see that it was loaded. Can you give us your best case for the proposition that that finding in Silvello isn't necessary here?
Well, again, I mean, I not being entirely familiar with the facts of the case, I may be misunderstanding them a little here, but in the first place, the case law supports the idea that the court can infer, although it's not dispositive, that someone has a higher degree of familiarity with an item that's contained on their person than an item that's concealed in a container or in a car or something that they're not sort of.
What do you think your best case is for that?
For
that proposition?
I think there are a couple of different answers. First, obviously distinguishing, and this is bleeding it into a little
I just mean your best legal case, not your best argument, your best legal case for that proposition.
I think the best argument, it's Resende with respect to the knowledge about the firearm being loaded, as opposed to Resende with respect to the knowledge about the large capacity. Obviously, there are Resende on that. So I would say it's the discussion in Resende about the defendant's familiarity with the item that he was found in possession of.
Can you turn to the duplicative conviction piece, that argument?
Certainly. I don't believe the defendant's argument with respect to this can be sustained. A firearm and a magazine are defined distinctly legally, and they are also physically distinct items that do not rely on one another in order to qualify as.
Okay, counsel, that I hear you. But what makes this case unusual is the fact that the defendant could have been charged either way under the statute, and in theory, same penalties apply, as I understand it. And one of those paths would have been duplicative, and the other path, you're saying, would not be. Do you have any case precedent that addresses this odd situation where the Commonwealth gets to choose between two otherwise congruent charging choices where one is duplicative and the other isn't?
I actually did want to address, because I know there was some discussion, and I'm not sure, please stop me if this is not answering your question, but I saw that there was some discussion earlier regarding whether the defendant would have been facing the same set of potential sentencing if he was charged just with the 10M possession of large capacity weapon, and he would not have been, because the Armed Career Criminal Statute does not attach to a 10M violation. It only attaches to 10A, 10C, or 10H of Chapter 269. So it would have been, I mean, clearly that's why we charged this way, because you need to charge under 10A.
No, but I'm talking about a 10M violation for the large capacity magazine as compared to a 10M violation for a large capacity firearm.
Understood. Well, but the bottom line is once he was charged with 10A, he was still subject to an additional charge for the fact that he had a large capacity magazine, because the firearm and the magazine are separate. And I note that it's actually in Commonwealth v. Costa, and I don't think the defendant raised this issue, which may be why it's not discussed more, but in Costa, the very weapon that the defendant was found in possession of. He was charged actually with 3 violations for that weapon. He was charged with 10A possession. He was charged with 10M possession of a large capacity weapon, and he was charged with 10M possession of a large capacity magazine. He was actually charged twice for possession of large capacity magazine, one for the magazine that was in the gun on his person, and one for a separate magazine that was discovered. And while the court in Costa obviously found that the large capacity weapon conviction was duplicative, the conviction for a large capacity magazine, to wit, the magazine that was inside the gun, was allowed to stand in Costa. So the court had an opportunity to evaluate. And again, I don't think the defendant raised that issue, but the court did. Sorry, please.
How does that tie into Judge Milkey's question? I think what Judge Milkey is saying is if the Commonwealth had charged this as possession of a large capacity weapon and possession of a large capacity feeding device, those convictions would have been duplicative. Do you agree with that?
Yes.
So it's a weird circumstance to then say they're not duplicative when you simply charge under a separate section that the possession is of a firearm.
And if I may follow up, did I just hear you to say that the reason why you charged as the Commonwealth charged as a large capacity firearm was for purposes of making that an ACCA eligible conviction?
No, we charged the possession of a firearm, the 10A, because that.
Excuse me.
Yes.
Yeah, that there was a decision made to charge under 10A rather than as a high capacity firearm under 10M for purposes of because of the ACCA. Is that correct?
I should clarify that I didn't make the indictment decision in this case. I have made similar decisions and have made them for the reason that I articulated, which is it gives us the ability to attach the armed career criminal sentencing enhancement.
It seems weird that you wouldn't be able to attach the sentencing enhancement to a high capacity, a charge of possessing a high capacity weapon.
I agree that it's weird, but that is what's in the statute.
Now, and I just want to clarify, you're not making any argument that 10M is essentially just a sentencing enhancement, like, for example, 10N is. And the reason why 10N and 10A are not duplicative is because the legislature just wanted an enhanced penalty. But you're not making that argument here.
No, it's a separate offense. And in this particular case, it's a separate offense targeting a legally and physically distinct item.
You appreciate, though, that it raises, at the very least, policy questions, which we may or may not be at liberty to address. That level of discretion with that level of consequence by the expedient of taking the magazine out and putting it in front of the jury separately.
I don't think the physical separation of the two items is what renders us able to charge them separately. It's the
I would agree, but it was a smart trial attorney who did it. There is a way in which, and it may be perfectly permissible, but I understand the defendant's argument that this smacks of unfairness at some level.
If we were to agree with the defendant on this first argument, what, in your view, which conviction would remain?
Well, I guess that would depend on how the court rules with respect to whether we sufficiently proved the.
Assume everything's sufficient.
In that case, were it to be remanded with everything remaining but for the duplicative convictions, my guess would be that we would pursue the conviction under 10A so that the armed career criminal enhancement could remain. I don't want to speak.
So the magazine would be the lesser offense.
Lesser, but not lesser included.
And you would argue, I assume, that under Vic, we don't look to the facts. We don't look to the fact that they were one gun, they were one firearm to start, that the statute permits them to be separately indicted.
No, I don't think putting together renders them one item. They continue to be separate.
Yeah, as a matter of the statute, that we don't look to the facts, right?
Correct.
And I have one last question for you. How do you distinguish what happened here from the cases where we found it's duplicative when the convictions are for the ammunition in the gun and the possession of the gun?
Again, in this case, I think they're separately defined statutorily, and that isn't about, those cases are about the gun being loaded and the ammunition in it. So even there, you can still charge possession of a firearm and possession of ammunition. You just have to choose between whether you want to charge it as loaded or charge the ammunition separately. So even there, you have an item inside a gun that you still have the ability to charge separately from the gun itself if you decide to pursue. In that case, it would be a 10A possession of a weapon or possession of a firearm and a 10H possession of ammunition. So even there, it's not about the sort of physical placement of the item inside the gun. It's about choosing between two different statutorily defined ways to address the presence of the ammunition inside the gun.
Okay, your time is up. Thank you very much.
Thank you.
Thank you both. Well, the case is submitted, and thank you for your helpful argument.
The case is now being recorded.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. With me today are Justices Milkey and Justice Sullivan, and my name is Gabrielle Wolohojian. I want to remind counsel that even though we are in this electronic format, all the customary rules of argument in our courtroom apply, which include that argument is limited to 15 minutes per side with no rebuttal. This case is partially impounded, so I want to remind everyone not to refer to anyone's full name, but rather by the initials. And with that, I'm going to call this case, which is KK versus RG, case number 2020P0507. Attorney Darji, we're ready whenever you are.
Your Honor, good morning. Please the court. My name is Ann Darji, and I represent the appellant defendant, RG, in the 209A abuse prevention order that is at issue. Recognizing that the court has reviewed the briefs and reviewed the appendices, I would like to turn first to the issue relative to the appearance of impropriety expressed by the trial court during the ex parte hearing that occurred on February 19th, 2020. There were two specific statements made by the court during the ex parte hearing. First is found on volume 1, page 7. The court stated to the UKK, who is the plaintiff and the only party present at that ex parte hearing, he stated, "It's been a long time." In her opposition, we learned that the defendant had a personal relationship with the court some years ago when a court reporter. Page 10, volume 1 of the transcript, the court then states, asks, how is Attorney Berg, who is the employer of the plaintiff, and states, say hello to him for me. Again, we learned from the plaintiff's opposition brief that she has that her employer, Attorney Berg, had a relationship, a professional relationship. There was also a personal relationship, can only be assumed that he had a professional relationship, that they were law partners some years ago. So as a result of this exchange, it becomes clear that there is certainly an appearance of impartiality given by the trial court. And the concern that was not disclosed on the record, or that there was not any attempt made that was clear on the record to have a different judge hear this matter is concerning.
How can we evaluate that argument on appeal on this record? I mean, judges say things to lawyers all the time in terms of, oh, it's good to see you again, where their only relationship may be in a professional capacity. So, I mean, wouldn't we have to know more to evaluate whether or not this was improper or not?
I think that certainly more information would have given some guidance. I think the issue is the appearance of impropriety. We have a fairly clear standard that there is an objective standard. It's found in note 5 of rule 2.11, which is cited in the brief I'm sorry, in fact, it's note 1, that the objective standard requires disqualification where the judge's impartiality is reasonably questioned by a disinterested observer. And so
does that mean you're asking us to simply look at these portions of the transcript and ourselves apply some objective standard to determine whether it raises that question?
in part, yes, Your Honor. I think the concern,
how is there anything other than that? There's nothing other than that in the record. They're just these two short exchanges. It's good to see you again. And how's attorney so-and-so? And that's it.
and a request to say hello to him for me.
Sure.
And I think that then the additional information provided in the opposition brief that there was a professional relationship is important. I think that I would argue there's certainly a heightened standard when it's an ex parte hearing. There was no other attorneys present. In fact, there were no attorneys present. This wasn't, as Justice Milkey pointed out, that there are certainly moments where judges will acknowledge that there have been lawyers in their courtroom on a number of occasions. These statements indicate a personal relationship. There really is a very significant, I think, directive from the canon that indicates that there needed to be some disclosure. Even if this is not a case where with more information there's a determination that disqualification was needed, at a minimum it should have been disclosed on the record. I would argue that this court should have recused himself from hearing this matter on an ex parte basis, because
I want to turn to your second argument, which is, I take it, the sufficiency of the evidence with respect to the extension.
Yes.
Okay, so we don't have the transcript.
So the second part to some degree relies on what the argument relative to the ex parte hearing. Matter shouldn't.
But we don't have the transcript of the extension hearing. Is that correct?
Your Honor, I'm not. What we did in preparation for this brief is we had the record assembled, which included the transcript. We did provide the transcript to the lower court. It is not referenced in my brief. That's true. It was made part of the court file, and when we had the record assembled, we included a transcript of the second hearing in that. So I'm not sure what Your Honors have received as it relates to what was sent from the district court, the district court clerk.
The transcript needs to be included in your appendix.
Right. And so from our argument, Your Honor, is that second hearing should not have occurred. That the fundamental issue and really what I believe this court is faced with, perhaps on some extent a first blush impression, that the second hearing, that 10-day hearing, is not designed to be essentially a second bite at the apple. It isn't designed to allow a plaintiff to then have an opportunity to gather additional evidence and create a new presentation for the court on that during that 10-day hearing. Our argument is very specific as it relates to the ex parte hearing. The standard was not met at the ex parte hearing. And so we're asking.
I have to interrupt you for a second. I always get these cases, they're hard for me to remember because they're all by initials, the names. But there are cases that say that if the extension hearing is affirmed or remain, not attacked, or then we don't look at the ex parte hearing at all, because the ex parte hearing is subsumed into the second extension hearing.
And I am certainly aware of those cases. Yes,
Right.
Judge.
So how is it that you don't run afoul of that
Because I
by not providing us a transcript of the second of the extension hearing? Because I don't see how we can reverse the extension without the transcript.
Because we would argue, Your Honor, that you don't need to reverse the second if you reverse the first. The ex parte hearing, if a review of the ex parte hearing indicates that it should not have been issued in the first instance, the second hearing becomes unnecessary to review. And the concerning
seems to be contrary to the holding of these cases. If the second one is affirmed, we never look at the ex parte.
And I recognize that there have been cases like that. I think for that to be the only view from this court's perspective is to say that any decision made at the ex parte hearing is now not reviewable.
But we're not saying that. We're saying, though, it's not reviewable unless you also ask us to and succeed in reversing the subsequent one.
That part, Judge, I do not believe that there's clarification in the case law for. I don't think that there is any directive that says that you were required to first look at the evidentiary hearing and then subsequently we will review the ex parte hearing. I certainly recognize the case law indicating that when looking at the second, the first is subsumed, but in this case, we're asking you to only look at the first hearing. Don't think that there's any case law that says we can't only look at the first hearing, we must look at the second hearing and then decide about the ex parte hearing. That isn't what the case law at this particular time sets forth. And I do think
we'll be able to check the cases ourselves.
Yes.
But if the second hearing is not challenged, which is what I hear you saying now, that you're not challenging the extension order.
Yes, we are, Your Honor. We are challenging these.
So if you're challenging the extension order on the basis of sufficiency, which is what I understood from your brief.
I would argue that we are, yes, but that we're also yes, we are challenging the extension order, but we are also on the basis of sufficiency, but also challenging the extension order on the basis of the improper issuance of the order in the first instance at the ex parte hearing. I think there are two pieces that flow into that request.
But in putting aside what the cases do or do not say, how can it be that if a particular plaintiff at the ex parte hearing doesn't produce enough, and yet you then have a hearing after the defendant is notified, and at that hearing, the plaintiff puts forward evidence that is sufficient to justify a restraining order, it can be that, oh, we're going to ignore that. It doesn't matter that she has produced all this evidence to the need to protect herself because there was a screw up the first time, it's over.
I think that logic then is to say that any of the whether or not the order is issued properly in the first instance now never matters. It essentially never matters whether or not there was enough presented on the first instance, if on the second try that there was enough presented. I don't think that follows some of the basic tenets in these cases.
Well, put differently, why does it matter if at the hearing after notice there was enough evidence presented? Do we really, what difference does it make to someone in your client's position whether or not there was enough the first time?
Because, and this may be from a procedural perspective, the court always has the court on the ex parte or presented with that emergency order always has the opportunity that rather than issue the order, which is essentially creates an abridgment, and in these kinds of cases, a specific kind of abridgment of rights, the court can decline to issue the temporary order and schedule it for hearing. The judge does have that opportunity, and the judge can say, I'm not going to issue this on an emergency basis, perhaps because sufficiently the from an evidentiary perspective, it isn't sufficient. Then the court can schedule it for hearing and at a 10-day hearing. Now that is the evidentiary hearing that's important. What happened in this case is that there was an ex parte hearing. The court proceeded with it. There was insufficient evidence to issue it in the first instance. And now he's in a position that you go back in front of that judge, have a 10-day hearing, and allows the plaintiff to present additional information that he didn't have, or he or she didn't have in the first hearing. Creates a second bite at the apple sort of scenario. And I think that to do it this way creates a situation where a judge can issue an ex parte order on nothing. Essentially, this allows a judge, a trial court, to issue that ex parte order on almost no hearing or no evidence, and with no ability to review it.
Are you familiar with the case CRS versus JMS?
If I could have just a fact pattern, I probably would be.
Okay, well, this is the case that it's not worth it for the facts. It's worth it for this proposition of the law that you aren't entitled to go back and relitigate the ex parte order if you're not relitigating the extension order.
But I think then, Judge, I fundamentally disagree with that as a concept, because again, you're insulating the trial court. That ex parte order is entirely insulated from an abuse of discretion. This court never has the opportunity to review what has been done at a hearing. The ex parte hearings are evidentiary in nature. There is evidence presented. There's an affidavit. There's typically testimony. And in this particular case, on that ex parte hearing, there was aside from the appearance of impropriety, we're now left with the possibility that as a result of that impropriety, that this issue was ordered just as a matter of convenience without having met the standard, out of deference to a personal relationship. And yet the statement is that if on a second try, 10 to 14 days later at this second hearing, if the plaintiff has, for example, prepared enough, has counsel, or is able to provide new evidence that wasn't given at that ex parte hearing, now that defendant is in a situation their rights were abridged improperly at that first ex parte hearing, and there's simply no recourse. I think the argument is that simply can't stand. There has to be an opportunity for this court to review what was done at an ex parte hearing, because in these 209A abuse prevention orders uniquely abridge rights, create a criminal, in a criminal context, behavior that would not be criminal for anybody else. So to allow that ex parte hearing to have no ability to review, assuming that at the second, I call it the second bite at the apple, but at that second hearing, if there is allowed to have enough evidence and enough new I think creates a problem, certainly a problem for the process, for sure. So in short, I think that a review of the record and a review of the affidavit makes clear that this was certainly harassment type of behavior that's alleged, but there were no threats. There were no sense of abuse or physical harm. So I'd ask that Your Honor vacate the order.
Thank you. Your time is up. We have your argument. Thank you.
Thank you.
Ms. KK?
Yes. Sure. Okay. I want to start by saying that when I went to court for the ex parte hearing, and the judge said to me, "It's been a long time," I responded, "Yes, Your Honor. I met him when I was 20 years old. I am now 61 years old. 61 years old. That was 41 years ago. And I had just become a court stenographer, and he had just become an attorney. And I knew him for a short time and never seen him again in all that time. So that has nothing to do with this matter." And then when he said to me, "How is Attorney Berg?" I responded, "He's very good, thank you." The reason why he knew that I was employed by Attorney Berg, because I had submitted the plaintiff's confidential information form, and it asked me where I worked and what address. And that's how he knew I worked for Attorney Berg. And this has nothing to do with my restraining order, me going to court for my ex parte hearing. I went there because I was afraid and I feared my life because this man is dangerous. He has done many things. He has an assault and battery case against him that he pled guilty to, and he's on probation. He attacked the neighbor at the end of my street, and they filed charges against him.
You have to stick to the record that's on, that we've got in front of us.
Okay, well, the record, okay, this is what I testified to. At the hearing on March 2nd, the court heard my testimony regarding the extension of the order. When I went to court for the ex parte hearing, that was a temporary order. The defendant had every right to prove his case, and he said nothing, that he just lied about spitting on my car. He said he never did it. And I had photographs, and I submitted all that with my complaint at the beginning of this process. So he had every right to submit his evidence. So he has, I testified about his verbal abuse and intimidation against me. And I testified how he publicly ridiculed me in front of an audience at my daughter's basketball game. He said to me, quote, "I wish you fucking died on the operating table," end of quote. Quote, "I fucking hate you," end of quote. Quote, "You fucking bitch," end of quote. Quote, "You're a fucking cunt," end of quote. I have to live through all this that he keeps saying to me all the time. I'm just so afraid. You don't understand. He blocked my vehicle in at my daughter's school so I couldn't back out. He spit on my car after verbally attacking me at my daughter's basketball game. He gave me the middle finger in front of my daughter. And to this day, he just continuously laughs at me all the time, like he's crazy. In addition to doing this, he's also done damage to the marital home I live in. He tore up the front yard by burning rubber in his truck, destroying the grass. He broke the legs off my ceramic dog outside the marital home. Those photographs were submitted to the court on day one. And when they filed their appeal, they didn't submit those photographs that I submitted. They left out all this. He put cow manure in my mail, in the mailbox. He stole my mail. He bent the sensors in on my garage so it wouldn't close. And he stole the transponder out of my car saying, "I'm not going to pay for you to see your fucking lovers." I'm so afraid of him that I sleep with a hammer under my pillow and I carry mace. To this day, I still do, because you never know what he's going to do next. This is the kind of person he is. At the marital home I live in, it's all woods around my house, and there's a pipeline behind there. And the neighbors have seen his vehicle parked there, and he can see my house at all times because he took the monitor and the cameras that were outside the house. He took them when he moved out of my house, so I don't have cameras anymore. And it just scares me to death because I don't know what he's going to do next. He has also mentally and physically abused my son and my daughter, and there's been 3 cases filed with DCF, and the Westfield Police Department filed the case.
Was that, excuse me, ma'am, was that in the record before the judge at the extension hearing? What you just told us?
Yes. He went crazy. When he goes crazy, he has this evilness coming out of his eyes. He loses control. He doesn't know how to control his anger. And that's what really scares me, because you don't know what he's going to do. And he did that to my son. And that's when I kicked him out of our house and told him he needed to get help. He needed to go to anger therapy. But he said that was bullshit and never did. And also my daughter ran away one time because of him. And we were all afraid of him. I want to find one other part. Mr. Gordon also has a serious, RG has a serious alcohol problem. He's an alcoholic. He has anger and paranoia problems. Now he smokes pot and hasn't worked in over a year. The combination of his alcohol abuse and anger issues makes him, quote, a ticking time bomb, end of quote. I am so afraid of him and fear every day what he is going to do next, as he is so unpredictable. I fear my life, I really do. And I need to have a restraining order for the rest of my life, because I feel like he's never gonna leave me alone. He has major issues. So, and I have proved my case for a restraining order. And just because the judge said hi to me and how are you doing, it has nothing to do with this.
I think we understand your argument, Ms. KK, and we have your briefs.
Yes.
Is there anything else you'd like to add?
I proved the restraining order that I am in imminent fear. Let me find it. I have to find it on my notes. Oh, let's see. I have it here. Yes. Abuse is defined as Massachusetts General Laws Chapter 209A, Section 1, as the occurrence of one or more of the following acts between family or household members. B, quote, placing another in fear of imminent serious physical harm. And he has placed me in imminent serious physical harm. And there was a break-in my house 2 weeks ago through the basement window, and he set off the alarms just to scare me. You can't get it.
Was that part of the record before?
No, that just happened 2 weeks ago. But he continues to do all these things, and I am really afraid for my life. And I thank you.
Thank you. Are there any questions from the panel? No, I don't see any. We have your helpful arguments, we have your helpful briefs, and the case is submitted.
The case is now being recorded.
Good morning, everyone, and welcome to this, good afternoon, everyone, and welcome to this sitting of the Massachusetts Appeals Court. Your panel today is Justice Milkey, Justice Sullivan, and my name is Gabrielle Wolohojian. Although we are conducting this argument in this format because of the ongoing pandemic, the ordinary rules of our courtroom still apply, which includes the fact that each side will get 15 minutes to argue and there is no rebuttal. I want to remind counsel and my fellow panelists, for that matter, that the case is impounded and we must not refer to any party's names. We can only use initials. And with that, I'm going to call the case Berkshire Medical Center versus MS, case number 2020P 0467. Attorney Lewis, we're ready whenever you are.
Thank you very much. May it please the court, my name is Melanie Lewis, and I am here before you on behalf of my client, MS. First, I would like to address the notice sent to the parties by the court on November 23rd, asking us to be prepared to address the issue of mootness. In response, my client and I filed a 16L letter citing in the matter of FC, which was decided by the SJC in 2018 and seemed to resolve this issue.
Counsel, is it fair to say that your position is that to the extent the guardianship of Irma addresses this issue, it's been abrogated sub rosa by matter of FC?
I do believe that FC has resolved this issue, especially in regards to civil commitments cases and treatment orders pursuant to 8B, and beyond that as well. However, FC involved the 123 section 7 and 8 and 8B in this case involves 8B as well. And the court specifically spoke to it, saying that the parties in these cases have a continuing interest in ensuring that the orders were lawful and to remove stigma. The appellate division, I will add, also cited FC in a footnote to resolve this issue as well. And I hope this court sees it in the same way. If you have any other questions regarding that, I will address them. Otherwise, I will move to the merits of this case. Regarding the merits of this case, Your Honors, at the moment that the Section 8B hearing began, just moments after the civil commitment order issued, my client MS, under the law, was presumed to be competent to make her own treatment decisions, presumed to be competent to refuse medication, and to be free from the invasion of unconsented to bodily integrity. The only way to overcome this presumption is through the 8B proceedings, the first part of which consists of a determination as to competency to make informed decisions regarding treatment. And it's the petitioner's burden to prove that the respondent, in this case MS, was not competent to make those treatment decisions. They had the burden of proof. And in order to—
Counsel, what is your best case, and by that I mean citable court case, for the proposition that in the 8B proceeding, at least when it follows directly on the heels of the Section 7, Section 8 hearing, has to start from scratch?
Well, I will move to that then. I was establishing that in the essentially four corners of the 8B hearing, there was insufficient evidence, sufficient facts were not presented. And as the appellate division did agree with that, but then said that was permissible because presumably the court incorporated 7 and 8 facts. So in response to your question, I think there are a number of things that speak to that. One is Section 8BB, which firstly states that the petitions in the 7 and 8 and the 8B must be separate. And also I would refer the court to the standards of judicial practice regarding civil commitment cases and the authorization to treat, Section 7.02, which—
What's the precedential value of a handbook for judges?
Well, in Massachusetts, this is guidance for the court. I will speak to some other authorities as well, but I did want to bring this to the court's attention because it specifically does state that the court, considering an 8B petition, may not give any weight to a civil commitment petition or to a civil commitment order.
But that's a different question from whether or not the judge has to hear new evidence from scratch, isn't it?
Well, I think it carries a lot of weight in that regard because the substance of the order is based on the facts that were heard during the 7 and 8 hearing.
May I ask you a different question? Why is it that we think of I know you keep calling these separate hearings. I'm not sure I understand why they're separate hearings. They're heard on the same day without interruption. There was a ruling made on the 7 and 8 petition first, and then they proceeded to the 8B petition. But why are these separate hearings? What makes them separate hearings?
Well, I believe that the legislature in designing the statute did differentiate between the two statutes, and the two hearings involve different considerations from the court.
Oh, sure, but look, if we have any, and I'm just using this as a hypothetical, not saying that it's perfectly analogous. You have a motion hearing in a case, and there are 5 motions on to be argued, but they're all heard at the same hearing before the judge. They're just 5 different matters that are raised, or 5 evidentiary matters. Why are these separate hearings as opposed to separate petitions heard during the same hearing?
Well, one issue that I think is of particular importance, in addition to the fact that there are separate issues and separate burdens of proof, I think this also demonstrates the distinction or the difference between the two hearings, and that's related to the privilege, psychotherapist patient privilege. So in 7 and 8 cases, in civil commitment cases, there's an exception to the privilege, so that it does not have to be established during that hearing that there was any kind of warning, a lamb warning or any other type of warning, and that there was a knowing and voluntary waiver of privileged information. And yet in 8B hearings, there is a statutory protection of privileged information.
Okay. Assuming you're correct on this legal point, where in this transcript can you point to where the counsel would have objected and therefore evidence of the waiver of the privilege came in when it shouldn't have?
Well, I did list a number of instances where during the 7 and 8 hearing, there were a number of what I would argue are privileged communications, which were testified to during the 7 and 8 hearing.
And by, excuse me, but by privileged, you mean they would have been privileged in the 8B hearing in the absence of a lamb warning? Is that your argument?
Yes.
Right. And if you could just assist me through this. The doctor who testified was not a court-appointed expert, correct?
Correct.
He was the treating physician.
Correct.
Correct. Do lamb warnings apply to the treating physician?
I believe that there is case law, Walden Behavioral Health VKI, I believe is the case that says that there is an exception. There does not have to be a lamb warning in the context of the 7 and 8 hearing.
Right. You're saying that in the 7 and 8 hearing, the testimony could come in, but it couldn't come in the 8B hearing, if I understand your argument correctly.
Yes.
And I'm asking you for what is the case law support for that argument, because if lamb only applies to the issue of lamb warnings only applies to court-ordered experts, I'm not sure how we make the leap. So do lamb warnings, has there been an extension of lamb to the 8B context for treating physicians?
I believe that 8BH specifically states that in the context of 8B hearings, testimony can come in from communications, privileged communications, but before those communications are even made, the doctor needs to provide a warning indicating that those statements could be heard in court and that there is a waiver. So that's within 123 section 8BH.
But how does that work in the context where we're not dealing with a court-appointed expert and we're dealing with a treating physician who's talking about what he did in treatment when no such warning would be given?
I don't believe 8BH says that it is only relevant to court-appointed physicians.
I'm just trying to understand the mechanics of how this would work. Are you saying that before a treating psychologist or psychiatrist can treat a patient, he has to give them the warning from the outset that if called to testify in a section 7, section 8, or section 8B hearing, that he or she might divulge this confidential information?
I believe that's what 8BH says. Okay. And that, and we go further to ask the court to consider whose obligation it is to establish that the warning was given and a knowing involuntary waiver.
Counsel, I'm still looking for a specific example, because when I asked for this like 5 minutes ago, you said you have a number of examples in your brief. As I remember those examples, they have an abstract quality about them in terms of these are subject areas that could touch on their communications. I'm looking for a specific example where you're saying counsel would have objected to this specific answer because there was no waiver here.
I'm sorry, I don't believe, I'm sorry if I hadn't answered your question before. I can't think of a specific case that I cited on that particular point. I believe in response, I was going to refer to care and protection of Isabel, but that is not on the point.
But I'm not looking for, in this instance, a case site. I'm looking for, I was prejudiced on the waiver, or my client was prejudiced on the waiver issue because this is what I would have objected to. And I would have moved to strike this particular answer. I'm not seeing where the psychiatrist gave up confidential information from his client.
Well, in the 7 and 8 hearing, on page, I could go through pages, record appendix page 48, he talked about conversations that he had with MS about staying on the medication. On page 44, there was testimony about what MS said to the doctor, and that in their conversations, she was confused with memories versus reality. He testified on page 45 of the record appendix regarding accusations regarding parents raping her, accusations about staff raping her on page 46. On 47, he said he discussed with her whether she felt safe or not safe. On page 49, and on page 49, possibly 46, there was testimony about her diagnoses and delusions, hallucinations, paranoia. On page 51, there's reference to description of disorganized thinking, again, talking about my dad raping me, my dad controlling me. her feeling angry.
And
her
your
talking-
counsel, your position is none of that stuff comes in because of the lack of proof of waiver.
That's correct. And without it, there was insufficient evidence in the 8B. So the prejudice would be with all of that coming in. That was the prejudice if the judge did support his 8B order based upon those 7 and 8 privileged communications.
I'm going to check to see if there are any other questions. Thank you. Your time has expired.
Thank you.
Attorney Carpenter.
Thank you. May it please the court, my name is Jennifer Carpenter, and I'm here today on behalf of the appellee in this matter, Berkshire Medical Center. I would like to begin with the issue that this court asked us to address, and that is the issue of mootness. I disagree that the matter of FC resolved the confusion with the guardianship of Irma. And the reason I say that is because all of these cases turn on the issue of personal stake in the outcome. What is the appellant's personal stake? And without that, the issue is moot. Here, like in guardianship of Irma, where the court found that the matter was moot and underscored that mootness on the basis that the appellant there was subject to an ongoing commitment and a 8B medication order. Here, the appellant is also subject to a Rogers order out of the Berkshire Probate and Family Court. And although that is not currently before this court, I did, in reviewing the docket, see that she has been the subject of a Rogers order out of that court since September 27th of 2017, 3 months following the expiration of the order in this case. And like in Irma, the personal stake or the stigma or the privacy concerns that the court found compelling in matter of minor do not apply in this particular instance. And based on that, we would ask the court to find that this matter is moot. And if there are no further questions on that, I will turn to the substance of the appellant's arguments in this case. The issue of competency and whether or not there was sufficient evidence in the 8B hearing as to competence, the appellate division found that there was not. We disagree with that and say to this court that there was sufficient evidence in the 8B, that there was evidence of competence on direct examination. There was also evidence of the lack of competence during the cross-examination. Neither of those points were addressed in the opinion.
I understand the point you're making with regard to the cross. What is the evidence on direct that MS was not competent?
On direct, Your Honor, at page, the record appendix 87, the question posed on direct, and do you believe if she were capable of making an informed decision that she would agree to take the antipsychotic medications? There's an objection to that question. The judge asks, does he have an opinion as to whether if she would come up and then she would agree to take the medication? I would ask the court to read into that if she were competent and then she would agree to take the medication. The answer, yes, that is the question. He allows the doctor to answer. Although that answer is not on the record, the next question is, on what do you base that opinion? There you have the doctor then saying she has agreed to take the Closeral in the past.
But why shouldn't that testimony be fairly read as assuming she's not competent? Would she agree to this if she were competent, as opposed to proof that she's not competent?
Sure. The issue of, could it have been a cleaner question? Possibly. But certainly the question there assumes that she is not competent, and his answering that question as posed assumes that he's agreeing with, I know you have to take a couple leaps to get there, but I disagree that it could be read in the alternative.
Assume we were to agree with the appellate division that there was not enough evidence in the 8B, and I take it you don't quarrel with the notion that these are separate hearings. So assume that we were to agree with the appellate division that there was not sufficient evidence during this 8B phase or segment to determine competence. What is the best authority for, I have two prongs to this question, for the notion that the judge could turn to the evidence elicited during the immediately preceding section 7 and 8 petition. And secondly, that the judge could do that regardless of the different requirement in the section 8B hearing with respect to privileged communications.
First, I do acknowledge that these are separate hearings. I do, however, disagree with the narrow reading that the appellant has taken in this case. I do not see this as a situation where the court is not permitted to consider the evidence it just heard only moments before. And I believe, to answer Your Honor's question earlier to appellant's counsel as to why are they separate, the answer is the court cannot even get to the 8B before it even makes a finding on the commitment. And there's an entirely different process through the Uniform Probate Code in the probate court that allows for individuals to get Rogers orders outside of the scope of a commitment proceeding. And so you don't even get to the 8B again unless you've first gotten through the 7 and 8. Once you're into that 8B, however, it's certainly proper for the court to consider the evidence that it had heard, again, just moments before. And as the appellate court, the appellate division said in its opinion, it would be an enormous waste of judicial resources.
Sure, but I'm asking you for some authority that says that the judge can do it that way. Like a case, legal authority.
Your Honor, I believe that this to be an issue of first impression before this court.
Okay, so now let's turn to the question that if a judge decides to do it this way, does the judge need to give some indication to the parties that that's how the judge intends to proceed? Because maybe the parties would elicit, go back and delve some more into issues that they decided they didn't really need to go into during this phase on section 7 and 8 hearing. But here the judge doesn't do that. The judge gives no indication that the judge intends to rely on evidence elicited during the previous hearing. So doesn't the judge need to give some indication that's what the judge is going to do?
And Your Honor, in this case, I believe the judge, there was that indication and that notice had been provided. And
where? How?
The very first question that is posed to Dr. Giovanone in this case required him to draw upon his testimony as to the appellant's mental illness.
I see that that's an assumption. You could assume that Berkshire Medical's lawyer thought that the judge could do that, but I don't see any indication that the judge said that that's what the judge was going to do.
The other important fact in this case as well is are the proposed findings that were submitted by the appellant in this case prior to beginning the 8B hearing altogether. Much of what the appellant was asking the judge to find with regard to the 8B came solely from testimony and evidence out of the 7 and 8 hearing. And while, of course, those findings were prepared prior to the start of the hearing, the fact that they were submitted before testimony even came out suggests rather strongly that the appellant believed the court would be, or was under notice, and in fact was pointing the court to the 7.
Not a question about the court being on notice. It's a question about the parties being on notice by the court. But regardless, so I take it you have no legal authority for this. You're just, I take it from your answer. The second question, the second part of my question was, what do you do about the fact that with respect to privileged communications, there's a different issue in the Section 8B hearing, and that seems to have just gone by the wayside here?
Sure. While Section 8B does refer to the need for to have provided notice, it doesn't make the distinction as we see in the 7 and 8 as to a court-ordered examination. And in this case, it's not a court-ordered. There is no legal authority. I also believe this to be an issue of first impression before the court as to whether or not that exception applies in the context of an 8B hearing. To the extent that, and I know this is the appellant's argument, that testimony, assuming that exception does not apply in the 8B, to the extent that the court relied on what would be privileged communication in the 7 and 8 in ruling in the 8B, in this particular circumstance, the alleged or purported privileged communication is unclear, although I know counsel has cited to a number of areas. The respondent in this case, or the appellant herself, testified, and much of what she testified and what the evidence that was before the court goes directly to much of what the appellant is arguing now was privileged communication that should not have been before the court.
So you're saying the evidence of the privileged communication was before the court from her own lips?
That is correct, yes.
Okay. But I'm still concerned in terms of how we think about this case, about the practical aspects of this. I'm looking at Section 8BH, and it says, notwithstanding, these statutes relating to confidential communications, affidavits and testimony may be given, quote, provided that such patient has been informed prior to making such communications that they may be used for such purpose and has waived the privilege. Attorney Lewis has indicated to us that she understands that to mean, if I understood her correctly, that the outset of treatment, a provider must give these warnings that their confidences, a patient's confidences could be used in this way. What is your view?
My view, Your Honor, is that to require a treating psychiatrist to, at the outset of treatment, to provide this warning to every patient would create a problem in terms of that relationship. And if
it might, but what do we, tell me what this language means then.
Sure. That the
tell
language.
Tell me when it has to be given, because it's pretty broad.
Sure. And in the same, the reading of the privilege itself has been scaled back in future cases to apply only to the context of court-ordered treatment. And we would ask the court to find that this provision includes that same caveat, if you will.
When was this language adopted in the statute, if you know?
I do not know. I know that the statute itself became effective in 1986 and it was amended in 1992.
Are there any other questions? Thank you. Your time has expired. It's a very interesting case. We've been aided greatly by both of your arguments, so thank you for that. And the case is submitted.
Thank you very much.
You know when we are connected.
Okay.
The case is now being recorded.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court. My name is Gabrielle Wolohojian, and with me today on this panel are Justices Milkey and Justice Sullivan. Although we are hearing this argument in this format, all the ordinary rules of argument pertain, including that each side will receive a total of 15 minutes. I understand that the defendants will be dividing their time equally, so it will be 5 minutes per party. And there is no rebuttal. With that, I'm going to call the case of PAPKEN Hartunian versus Mercy Medical Center and others, case number 2019 P0834. Mr. Hartunian, we're ready whenever you are.
Okay. Good afternoon, Your Honors. I am Hartunian, representing myself, pro se. May I please the court? I have an honor and privilege to present my oral argument to the appeals court. I have 2 points and 2 reminders to the court. My first point is about disclosure. Defendants failed to disclose to Hartunian that the Emergency Medicine Solutions, a limited liability corporation, also known as the group, has been exclusively operating and running the emergency department of Mercy Medical Center since 2009. Furthermore, the defendants failed to disclose to Hartunian that Durkin has a financial interest in the group. Moreover, the defendant failed to disclose.
I'm sorry to interrupt, but I have a question for you on this argument.
Yes, ma'am.
Did you make a request to determine that information from the hospital?
I have a contract provided by Mr. Vegan, which is here, that shows the same fact.
No, that wasn't my question. I must not have been clear. My question is your argument that the hospital was required to disclose that information?
Yes.
On
yes.
its own, I know, without a request from you? Or did they have to receive a request from you first?
No, ma'am, this is the different story. This is a, it is exclusively contracted with the emergency medicine solution
I
that all
understand that.
emergency services, yes.
But your argument is they were required to disclose this.
Yes, that is
Is your argument that they were supposed to disclose this when you came to the emergency room?
Yes, ma'am.
Okay.
Because.
So what are you basing that? What legal authority are you basing that on?
Okay.
The statute?
No, the common sense. I went to get treatment from Mercy Medical Center, which I know charitable organization has been around 100 years, and we respect that. It's not first time that I'm going to go there, right? I expect to be treated by people that hired by Mercy Medical Center, not by any other profitable organization that who knows where they are. Their names are not listed in the medical record nowhere. And I get a bill from them as well as I get bill from the Mercy Medical Center. So what I'm saying is this is not only me, what I'm saying to you, if you go a doctor, if you go hospital, you expect to see on your medical record the organization that provided medical care for you. Isn't that common sense?
Okay, so you're relying on some kind of, let's call it common law, not a statute for this.
I don't know the statute about it. I am not aware about statute about that.
Justice Sullivan has a question for you.
I just want to ask you about Mercy. There was a judgment entered in favor of Mercy fairly early on, and while you did take a notice of appeal, there was no notice. The appeal was never entered in our court, and you received a notice saying that you had failed to docket it. Did you ever docket your appeal in this court?
Yes. Can I answer?
Yes.
Yes. That appeal was previously when case was not finalized. I didn't appeal that because I was waiting to case finalized and then appeal all against all defendants at the same time.
But does that include the Mercy Medical?
Yes.
Well, the difficulty is, though, that a separate judgment, just to let you know, and I don't want to use much of your time on this, but a separate judgment was entered, and we'll have to decide whether you could wait until the end. But why don't you move on to your other claims against the other parties?
Okay. My other disclosure statement is that Durkin, that the defendant failed to disclose for Hartunian that Durkin has a financial interest in the group. That was another argument I have, that they failed to tell me that they have financial interest. And Durkin itself, he says that he has shareholders of one of the major shareholders of the group. Moreover, can I go on?
Yes, you may continue. Unless we ask you a question, you should just continue.
Okay. So, moreover, the defendant failed to disclose to Hartunian that defendant Skypek was a student and she had no professional license to provide healthcare for Hartunian. Meantime, Hartunian had a legal...
Is this argument based on a statute? In other words, what imposed an obligation on them to disclose?
Yes, 70E statute, chapter 111, 70E statute, it says that I have right to reject a healthcare provided by student.
Okay, and who has the obligation to disclose whether the person is a student?
I think all defendants, they were working as a team. Everybody they contacted, I've seen Dr. Durkin.
But what about in the statute? Does the statute say who has the obligation to make that disclosure?
I don't remember now. I don't remember that now.
Okay.
Sorry. Yeah, I don't remember that now. Okay. And this is the kicker here. Had Hartunian been informed about stated facts above, Hartunian would not have been agreed to go on with the proposed treatment by the defendant. Because being a student, there's inherently risk involved there. Because he is there, she is there to, I'm sorry, it has to be. She is there to study, to learn. I don't mind that, but I have been right to tell about it, to let me know about it, right? And she comes in as a doctor alone. She said, I asked her, could you give me some medication, painkiller medication? She says, no, we don't give medication. It says our policy is that whoever walks in, if you walk in, patient walk in, we are not giving pain or any medication to them. So I say, okay, the policy is policy, but what can I say for them? Not only that, she didn't give me no anesthesia or local lidocaine to numb my hand before putting stitches on my hand. A doctor came, I had a 2-minute conversation with him. I started saying, doctor, please prescribe me some antibiotic. He said, you don't need it. I told him, how come? He says that your wound is clean. I told him, how do you know that? He says, I can tell you by naked eye. Guess what happened? 2 days later, I developed infection. I went to Bay State. They took X-ray. They find that some radiopack against foreign bodies in my hand, which probably they caused infection. I had to stay there 4 days, and after that, I had a lot of problem. What I'm arguing is this: if I knew that she is a student, I would have asked somebody else to come in to provide a decent treatment for me. I would have escaped being infected and going through all these troubles. And the nurse Hogan told me that I treated your legs, abrasions, and I left your room. Well, she was my emergency nurse, assigned emergency nurse. She's supposed to advocate for me. She's supposed to help me out. She's supposed to tell me everything there. And she left and she comes back at the end of the time. If she had stayed there, and one of the arguments, Mr. Vegan, is that she is nurse, she is not supposed to do stitching. She is not allowed to do stitching. How come she is not allowed to do stitching? But a student that, even though she is not medical student, she is allowed to put the stitching on the laceration hand. Doesn't make sense. And they don't provide any document, Your Honor. No job description, no policy, just they say it. And the trial court approves them and accept, because it is the veteran attorneys, they accept their work. And I am there pro se, I'm Armenian, she doesn't care about what I said. She said, Dr. Mr. Vegan says that it was determined that is going done by somebody else. By whom determined? Who determined that? There is no evidence. There is no evidence in his brief. There was a policy there. Okay, you could have provided a job description at least for your nurse, saying that you are not allowed to do that, or what you're allowed to do that. There is no job description. There is no affidavit by the no defendant.
Right. Do you want to address the trial judge's view that, do you want to address the argument that it is you who has the burden of proof on your claims, not the defendants, and that in the absence of a expert affidavit or an expert who's prepared to testify?
Yes, my second point.
That you haven't met your burden?
Yes, ma'am. My second point, first of all, I said about statement, but I said disclosure, they are non-medical facts. They are actionable material facts. They're not medical. You don't need expert to prove that whatever I argued already. My second point is about affidavit of the Dr. Mallory, my medical expert, whose judge relies on that medical expert's affidavit and denied my motion to continue the trial. Recently, Dr. Mallory sent me addendum, basically recanting his affidavit. I found recently that trial courts, if there is a motion based on recanting of material witness, a new trial will be granted. That's because even though judge makes no error, but if they found after trial, a material witness recant his testimony, that creates this due process issue. Based on that, they will grant new trial. My case here is we will trial too. We will trial, but not trial, live trial, but we tried by summary judgment motions. In summary, and there was an affidavit, there was a witness, which was material witness for my expert was material witness, right? And then his testimony as recanted. It says basically question number 4 is not my fault. He was aware that since September 4th and some 4 months ago, I've been told that where is the trial date, and he basically recanted that. I filed recently a motion to supplement that to motion to strike Mr. Weiser's motion, certain portion of Mr. Weiser's brief, and then I supplement that with a motion. Court allow me to supplement that addendum. Now it's in your file. There's addendum there, basically is recanting his affidavit, Dr. Mallory's affidavit with judge, motion judge. It says he cannot endorse my motion to continue to trial until she has affidavit from the Dr. Mallory. Dr. Mallory sent affidavit I filed with the court. Based on that affidavit, which was wrong, false for some reason, I don't know what reason, what made him to write false information in his affidavit, and judge denies my motion to trial, to continue trial date, right? And then just recently, 2 months ago, I received a recant addendum from Dr. Mallory saying that question number 4 states completely differently, which is not my fault. That means I have informed my medical expert that trial date is going to be March 13th.
Okay, we're going to have to leave it there because your time is up. Let me just check to see if either of the other judges has any more questions.
Your Honor, can I ask one more thing, please? Remind it. Okay.
No, your time has expired. I'm sorry. We're going to have to go to the other side. All right. You may want to put yourself on mute.
Yes.
All right. So I understand that we'll be hearing from Attorney Donovan next for Mercy Medical.
For Leah Skypeck, Your Honor.
Leah Skypeck, I'm so sorry.
That's okay. So may it please the court, my name is John Donovan and I represent Leah Skypeck. We're asking you to affirm the trial court's decision allowing Ms. Skypeck's motion for summary judgment. At the time of this incident in 2012, Ms. Skypeck was a student studying to be a physician's assistant. She participated in the care and treatment of the patient, but as a student, she could not order tests, prescribe medications, or make entries in the record. Early on in this lawsuit, a medical malpractice tribunal was convened, and the tribunal found in favor of Ms. Skypeck. Ms. Skypeck moved for summary judgment, and that motion was allowed in December.
That doesn't have any precedential or binding or effect, does it?
No, it doesn't, Your Honor. Of course, you can post the bond and proceed with the action. The court should affirm the decision allowing Ms. Skypeck's summary judgment because there were numerous independent, valid grounds to enter summary judgment. First and foremost, Your Honors, there was no expert affidavit to support any claim against Leah Skypeck. The affidavit.
You need an expert to opine on the failure to obtain consent.
Yes, you do, Your Honor.
Why?
Because the case law suggests that you need an expert to testify about what the medical provider should have known under the circumstances. And then, of course, they have to discuss the materiality of what the risk is.
Okay, but that's on the medical treatment, right?
Well, no, that's on the informed consent. I think
Okay, so what's the case for that? I mean,
Sure. If you look, Your Honor, at Harnish and then Precourt and their progeny, all of those cases stand for the proposition that you need to have an expert testify. And I think we also cited, Your Honor, this Messer case. It's Rakoukanakis versus Messer. That's 63 Mass App Court 482. And in that case, they talk about how you need an expert to make out an informed consent claim. I will mention, Your Honors, that it's our position that there isn't even a valid informed consent claim in this case because that doctrine wouldn't apply here. The allegation here is that there was some negligent treatment by the healthcare providers, and you can't really try to dress up a malpractice claim as informed consent by saying, well,
but what about the disclosure of your client's student status?
Well, I'm not sure that.
Well, I'm just going to ask you, is it not true that there's an obligation to disclose that created by statute?
I'm not sure that that is true, Your Honor. I know the plaintiff has referenced Chapter 111, the Patient Bill of Rights, for sure. But of course, that statute doesn't create any independent rights or obligations, and it certainly doesn't create or impose any rights or obligations, in this case, on the part of a student studying at a hospital or working at a hospital. What that statute does say, of course.
Go ahead.
I'm sorry.
Go ahead.
What that statute does say is if you can bring a malpractice claim pursuant to Chapter 23160B, which of course is the negligence claim. And in this case, that claim clearly fails because there's no expert opinion that supports any allegation against Leah Skypeck. I mean, the expert opinion doesn't even address her.
Let's go back to 70E for a moment. I read the amended complaint to bring a claim under 70E, and this applies to all of the defendants, so I won't take up too much more of your time. But do you find any place in the complaint where some kind of common law duty of disclosure is alleged versus Chapter 111, Section 70E?
I don't think so, Your Honor, nor do I think one exists, but it's certainly not in the amended complaint. The amended complaint simply references the statute.
All right, and I take it your position is that Mercy is out of the case. It would have been helpful if you had, rather than simply assert that, point out where in the record that was true, but we figured it out. Or actually, that wasn't you. That may have been somebody else. I can't remember who, but it was a bit of a hunt. But I take it your position is that 70E is not applicable to your claim.
That's exactly right. And I see that my time has expired. And so unless there's any other questions, we'll simply rely on the brief.
Thank you.
Thank you.
Let me check on questions. No, okay. Attorney Wiegand, I'm sorry, I'm sure I'm mispronouncing it.
That's all right. Weekend's fine, Your Honor. Good afternoon. On behalf of Nurse Hogan's, we submit that there was no error by the Superior Court in entering judgment on her behalf. As you saw, the gist of the basis for the judgment and argument below was that while she was the ER nurse that initially saw Mr. Hartunian, she played no role in the suturing in care of the finger laceration, which is the gravamen of this complaint. The complaint in this case the court should not lose focus of is that he received inadequate medical care regarding to this hand laceration that led to infection and further care. Nurse Hogan saw him, assessed him initially, saw that he needed to have sutures, informed the attendings, which was Dr. Durkin and Skypeck, and otherwise attended to his abrasions on his legs. She had no other involvement with him until the time of discharge when he was provided discharge instructions. And that was the heart of the summary judgment motion that was allowed by the court. In this appeal, plaintiff argues that the summary judgment was erroneously entered because it wasn't properly substantiated with affidavits. And I think he also makes an argument, from what I can understand from his brief, that the judge erred in not allowing supplementation of his opposition to all the defendants' motions for summary judgment based on certain medical records. The summary judgment motion, as you have it in the record, was properly substantiated. It had relied on Mr. Hartunian's own complaint, an affidavit of Nurse Hogan's, the excerpts from Mr. Hartunian, and again, the gist was she didn't have anything to do with the hand laceration and the gravamen of the complaint. As far as the court's ruling on the denial of his request to supplement the oppositions to all the summary judgments, there was no error there. Court has broad discretion as to such requests for leave. He relies upon two medical records, and you have them in the record. Record Appendix Volume 6 is a patient visit information sheet at pages 85 through 89. The EDM patient record at Record Appendix 6, pages 82 through 85. He asserts that he obtained these and that he hadn't gotten these before. There were multiple productions of his medical record. As to these two records, they have nothing to do with or provide any basis to disturb the judgment. They were not newly discovered, and they have no effect on the basis for the judgment that was entered for Nurse Hogan's. The patient information sheet that he relies upon was pertained to discharge instructions. It's a computer-generated sheet, and attached to it were standard computer instructions dealing with wound care for stitches and staples. They usually don't become part of the medical record, but pursuant to one of his requests, they were produced. Again, they have nothing to do with the merits of the argument or the judgment that was entered by the court as to Nurse Hogan's. There was the EDM patient record, a one-page summary nursing assessment, which he relies upon. It contains the exact same information in the records that he's had, multiple productions. The ED summary record at Record Appendix 6, 74 through 78. The ED physician documentation, Record Appendix 6, 79 through 81, and the patient audit trail, which begins at Record Appendix 6 at page 99. It's the same information. He tries to make this argument that it discloses that Nurse Hogan's never did an assessment and somehow that's material to the judgment. It's not. She clearly did an assessment. She notified the attendings, and they provided the care for the laceration on his finger and hand. So there was no error by the court, and certainly no prejudicial error with regard to his request for leave to supplement his oppositions. He makes no other, I just point out one final point. He makes no other argument as to the merits of the summary judgment motion. He did make submissions and arguments below, including an affidavit he relied upon from a purported expert. He has not relied upon that in this appeal, and I suggest that he's forfeited and waived those arguments. He simply relied upon those arguments I've just mentioned, and there was simply no error by the trial court in entering judgment for Nurse Hogan's. And I would rest there unless there's any questions. I would otherwise refer to the briefing.
No, I don't see any other questions. Thank you very much. Attorney Visser, I understand is Attorney Visser.
Thank you, Your Honor. May it please the court. My name is Christopher Visser. I represent the appellee, Dr. Durkin. I just will touch real quick where Attorney Wiegand left off regarding these purported newly discovered evidence that Mr. Hartunian speaks about largely in his reply brief. One thing that's unique to Dr. Durkin is those records were considered as part of the summary judgment record. Those records were included with Mr. Hartunian's supplemental opposition that the trial court judge did consider with those. And I will agree with Attorney Wiegand that the relevance of those records there basically is no relevance to those records. Mr. Hartunian wants the court to look at each individual medical record in a silo and disregard the rest of the records. And if that one record doesn't have the same information that appears on a different record, then that other record is fraudulent. And I would submit to the court that that's just not a legitimate argument. I also want to touch on, obviously unique to Dr. Durkin, was Mr. Hartunian's motion to continue the trial date. I think it's clear from the record that the judge appropriately exercised her discretion in denying that motion. She even went as far as to give Mr. Hartunian an opportunity to submit an affidavit under Rule 40 from his expert to support his motion. Specifically, she asked for 4 pieces of information. One was what the expert's availability was for a trial date. Was the expert's appearance for a trial date contingent on some kind of payment, whether that payment was made, and what Dr. Mallory's current understanding was of a trial date. And the affidavit submitted by Mr. Hartunian, purportedly signed by his expert, essentially did not respond to any of those questions directly. And especially if you look at that affidavit along with the emails that Mr. Hartunian submitted between him and his expert, there certainly is significant inconsistencies between the affidavit and the emails.
Can I turn your attention to Section 70E? Seems to me your client may stand in a different posture than maybe the other defendants. As I read it, there's the statute imposes sort of a right in the patient, or vests a right in the patient and maybe a duty upon the physician, because it says every patient or resident of a facility shall be provided by the physician in the facility the right, and then it says to refuse to be examined, observed, or treated by students. And I think Mr. Hartunian's allegation is that that did not occur here. He was not informed of that right or given the chance to exercise that right. And so why is it that that summary judgment, if I'm reading the amended complaint correctly, and if I understand Mr. Hartunian's argument correctly, why is it that summary judgment was appropriately entered on that claim?
Because I think 70E applies to the facility. I don't think it creates an obligation on behalf of the physician. I think
it says it shall be provided by the physician, but then are you saying that that means that the cause of action can only be asserted against the facility?
Correct. And then there could be then you could do a separate cause of action for medical negligence against anyone else that's not covered, that's not the facility itself.
So do you have a case that says that, because the statute does create a private cause of action, so do you have a case that says that cause of action can only be asserted against the facility and not an individual physician?
I believe we cited cases in our brief that stands for that proposition, that 70E is enforceable against the facility, not physicians. And I would defer to those cases cited in the brief. I think, on the informed consent issue, I think, what the cause of action would be against Dr. Durkin would be sort of what is created as the common law informed consent claim. And I think in this case, it would require an expert to, one, state what should have been disclosed, and then also need an expert to make some kind of causal connection between whatever is alleged and Mr. Hartunian's injuries, which we just don't have here.
I see your time has expired. Let me see if there are any other questions. No. It's a very interesting case. We've been helped by all of your arguments, so we thank you for that. And with that, the case is submitted. Thank you all.
Thank you, Your Honor.